I'm gonna record it right now. We're recording. And thank you, Rosemarie. So we're recording, we're live, and I'm gonna give you guys the video. I'll give you guys the slide presentation, and also we'll share this video with anybody who couldn't be here today so that they can also get their hours as needed. Make sure you do that, by the way. Let's get you guys renewed and ready to go. 2021 is going to be a better year, going to be a lot of work. So let's get started, guys. Let's talk a little bit about ethics and specifically what I refer to as ethical conundrums, dilemmas, and stickity wickets. I don't even know what that means, but it's just all the little ethical gray areas that we get into and that that sometimes we just don't know how to resolve. I want to take a look at Kentucky's Code of Ethics, and along the way, I want to apply what we learned to scenarios. And so, like I said, we're going to do some scenarios. I'm going to ask for your participation. But before we get there, I think we need to establish sort of a baseline. We need to understand, what a code of ethics is and what it means and how it works. And so, we're going to talk just a little while, a few slides about that. Then we'll get into the fun stuff. What I want to mention to you guys up front before we get started in the slides is that, you know, when somebody presents about ethics, I think it's important to understand where that person is coming from, ideologically, how that person views the world, how that person views ethics, views the profession of court interpreting. I think that's important because that person's experiences and beliefs will greatly affect the material, the information that you'll receive in any ethics presentation. That's why I'm not a huge fan of bringing people in from the outside to talk about Kentucky ethics, right? That's also sort of why I don't like necessarily going to other states specifically and talking about their ethics. I'm fine doing it on a national level to a national audience, but when you get at the state level, there are just some very specific interpretations regarding ethics that states have developed over the years. And I think it's important as you practice in different states to understand what that state's expectations are. And so telling you a little bit about me and about the way that I view ethics, and I think I can say this is our departmental view, right? This is sort of the culture, the ethical culture that we have here, right? So when you think about ethics, you think of it on a spectrum. And maybe you have a very conservative end, right? A very conservative way of addressing problems, right? And you have gray area in between here. And then in this side, you have, a much more we use liberal. We're in political times right now. We have conservative and liberal, and I don't really mean that in politically, but that's sort of what we have. You have somewhat of a conservative approach, and you have maybe more of a liberal, open approach, and you have the gray area. And so ethical behavior really is anything between these two extremes. We can't go too far this way or too far this way. We can't get outside, right? Outside of these two extremes. But anything in between, we can consider that as ethical behavior, right? Now, there are different interpretations from state to state. And so my view, Kentucky's view, Kentucky's approach to this is to lean pretty heavily toward the conservative side. When I deal with interpreter ethics, when I give you a response, you may ask me, okay, Joshua, what would you do in this case? Well, I can tell you that, more than likely my response is going to tend toward that conservative side, right? That's the type of response that I typically give in court. That's what I train, our interpreters here to do. That's what I would want from you guys, right? To lean toward that conservative viewpoint when you're interpreting in Kentucky. Some things are just right and some things are just wrong, but a lot of times we get into this area where there are lots of different choices you could make. And when you have that ability to make the choices, I tend to go toward that conservative side. So I mentioned that to you guys up front as we approach ethics. I think that's going to be important. That gives you some background in terms of what you'll see and the way that I'll explain things and why I explain things. I fully recognize there are several different ways to respond to many of these ethical conundrums. And we'll even say sometimes, hey, it's okay. We could do this, or we could do this, or we could do this. All of these are ethically acceptable. I would prefer to do this, right? But there are a lot of right answers. There are some definitive wrong answers that we'll probably talk about along the way, but there's a lot of right answers as well. Okay. And I'm pretty much comfortable as long as we're within these ethical parameters, as long as not working outside of those. All right. So just keep that in mind as we go forward here. We had a question from Elisa. Will there be an exam test or anything along those lines to turn in to get credits? No, there will not. Good question, Elisa. No, there will not be. So this is the honor system. I assume if you're here, you're listening. Maybe one day in the future, maybe next year we'll do that. But no, all you have to do is attend, confirm that you attended, and you will get credit. All right. So we're on the honor system. Good question, though. Thank you for asking. All right. So let's do this, my friend. We're going to go through here. Let me sort of close this in. Let's make this a little bit bigger here. I like seeing my slides to the side though, just because it helps a little bit. Okay, so ground rules. Do ask questions, but keep questions and comments within the scope of the discussion at hand. Remember the chat box, I'm watching it, but use it only for good. Don't use it for evil. Only one person may speak or chat at a time. Participate and ask questions. Absolutely. I want this to be interactive. So our objectives today, we're going to gain awareness about court interpreter ethics and the role of the interpreter. Let's see here, and hold on a second. Mojgan says she can't see my slides. Can everybody else see all the slides? Okay, good. They're still there. Yeah, Mojgan, we're okay. It just maybe the view that you have on your computer. That's an important point, actually, we should probably address. There are things I can manipulate on my side. I can share the screen with you, but in the end, your screen has to be set up. So Mojgan, play with it just a little bit on your side, adjust it. It's there somewhere. It should be there. Sometimes bandwidth can affect as well. So on my side, things seem to be working well. I'm transmitting well. Seems like everybody can see me and hear me. But if your connection were not stable, if it weren't very strong, maybe that would affect you seeing it as well. The good news is I will send out the slides afterwards. Okay, so keep that in mind. Just play with it a little bit. It should be able to pop up. So objectives today, gain awareness about court interpreter ethics and the role of the interpreter. That's going to be an important point. I want to talk not only about just general ethical guidelines. I want to talk about the role that we play, and I do think that Kentucky is really in the front of the pack on this. I really feel like we've led the way in terms of understanding the role of the interpreter in court and differentiating that from other things that interpreters can do at times outside of court, right? So we're really going to talk about that a little bit. I think that's important. We'll spend some time on that. We're going to understand ethical duties and obligations, again, as related to court. And we're going to learn to deal with ethical dilemmas in a professional manner. We're going to do some hands-on kind of stuff. It's going to be fun. Um, there's no perfect ethics training. I can't teach you everything, and we can't go over every scenario. So a lot of what we're doing today is just giving you tools to make good decisions, right? So we're talking through some of these things. We're giving you the background, and you have to take what you learn. And when you're in court and these random things come up, you have to apply what you learn. So that's really what this is about today, right? Within those parameters. Remember, we talked about it. Okay, so let's do this. I think we talked about that. We're okay. Let me go back down here. So let's define the role of the court interpreter first. That's a really good place to start. The interpreter is a professional who works for the court. When we say the court, we can understand that in different ways. If I'm in court actively, perhaps that means the judge. I work for the judge. In fact, in Kentucky, we consider that interpreter to some degree to be an extension of the bench, right? Your ethics line up much more closely with those of the judge than with, say, either of the parties, right? The attorneys for the parties, right? You're much more closely related to what the judge does and what the judge can and cannot do than what the attorneys can and cannot do, for example. Keep that in mind. We'll talk more about that. A court interpreter is what we call a language conduit. And what I mean when I say that is, you're listening to it, it comes in English and it spits out in the foreign language. It comes in the foreign language and you spit it out in English, but there's no modification of the message other than changing the language itself. The message, the conceptual information that you're passing from one side to another, it stays the same. That's important. That's what we call a conduit. So you're not really modifying, you're not editorializing, you're not giving your opinion, you're not changing it, right? You may clarify occasionally if you have a question about what is meant, but you can't clarify in terms of helping someone else comprehend that message. That's important. So we call this conduit interpretation. Comes in one side, comes out the other side. Of course, it's important to mention that that has to be, you have to make the modifications, the linguistic modifications necessary for the message to be appropriate in the other language. So when I say conduit, I do not mean that, hey, I heard this word in English and I spit it out in the other language. I didn't think about grammar or anything. I just translated words. I just said a bunch of different words in the same order they came in. That's what I did. It was word for word. No, that doesn't work. You guys know that that doesn't work. We obviously have to restructure the language as it comes in. I can change it. I can manipulate it. We have to do that. Otherwise, it don't make sense. It doesn't make sense, right? Having said that, though, I can't change the underlying concepts. We deal with those concepts, and that's important. So keep that in mind. We provide equal footing for individuals with limited English proficiency. We'll talk more about that in a moment. Equal footing is an important concept that we'll get into, right? We want them to understand what everybody else would understand, everybody else that speaks English. We want them all to understand the same kind of things, right? To hear the same things. Strives to maintain the integrity of the legal process at hand. So what? So that justice may be served. This is important here. People ask, maybe they'll ask you, what is the primary goal of court interpreting? What is your goal as a court interpreter, professional court interpreter, certified super duper interpreter? You've been doing this for years now. What is your goal? And you say, well, it's to be accurate and complete. Okay. It's to say exactly what's said. All right. It's to assist all the parties in understanding. Ooh, that's interesting. Most people don't ever come up with something like this, you know, maintain the integrity of the legal process so that justice can be served. All of those things I mentioned are important. We do want to be accurate. We do want to be complete. But why? That's a secondary function really of what we're doing. So I have to be accurate and complete in order to achieve my goal. And my goal actually is to make sure that the legal process works the way that it's supposed to work. What I want is for justice to be served. And obviously, justice can't be served if if the parties can't communicate. So we're facilitating that communication. Why? I do it to be accurate and complete. No, that's not why you do it. That's a part of what you do. That's how you accomplish your goal. But the goal itself is to maintain the integrity of the judicial process, right? So that the judge can make the right decision, so that the jury can make the right decision. That's what you do. That's important. Obviously, we have to be accurate and complete to do that, but that's secondary. What you really want is for everything to move forward. And man, it's beautiful when that happens, right? I love it. Love it when that happens. You go in, you do your job, right? Nobody notices you even. They don't say anything, and you walk out and the judge made the right decision and the person went to jail or they went free, whatever it is, because of the job that you did. That's fantastic. That was a job well done if you did it that way. Keep that in mind. All right. So let's talk a little bit more about this concept of equal footing. And to say equal footing, really, I much prefer the phrase equal opportunity to participate, right? Because we talk about equal footing, and I'm an English speaker, uh, native to this country. I've gone through this country's educational system. I understand this country's judicial system. And then can they really put the expectation on us as the interpreter to put a limited English proficient individual on equal footing with that culturally native English speaker? No, can't happen. There are all kinds of inequalities that we cannot overcome. So it's not equal footing. But what we can do is offer them through language an equal opportunity to participate in the proceeding. And that's it. That's really why we're there. I can't overcome the cultural discrepancies, the cultural differences, the lack of legal knowledge that that person has, the lack of opportunities for education that that person had to deal with in their country. I can't overcome any of that. It's not equal. It's not equal. But we certainly can offer them an opportunity to participate to the same level that someone, having been born here, would have, right? That's really what we want. Keep that in mind. That's important because your role is sort of based on that. You're not there to solve the world's problems in this context. You're there to provide an opportunity to participate, no more, no less. But that person still has the same obligation to speak up and to defend him or herself and to look for an advocate, right? An attorney if needed. You can't control everything and you can't solve all the problems. Keep that in mind. That's going to be important. So let's read through this together. What this means is if the defendant is an illiterate hermit from a geographically isolated region of a distant and remote country, he or she should understand as much of the message as would an illiterate and geographically isolated resident of the United States. But Joshua, what do you mean? How could this be? We're there to help them understand. Well, so you say. Let's read on. The interpreter's job is to place the non-English speaker on an equal footing with, and equal opportunity, let's say, not at an advantage relative to an average layperson who understands ordinary English. It's interesting. So is it possible as a court interpreter, you could go into court and the person would hear some more strange legalese, the judge is speaking this high language, the attorneys are using complicated concepts, and you say it all just fine, your interpretation is excellent, and the person doesn't understand, you see that they don't understand. Have you done your job? Well, is it possible for an English speaker, someone like us, right? We go in and hear it in English. I speak English, I've been here a long time, I understand what they're saying, but I still didn't really understand the concepts. Is it possible that such a person could come out of court and not really have understood what went on? Yeah, yeah, that happens on the English side, and it also happens on the foreign language side as well. That's okay. That's not within the purview of your responsibilities, right? That's not your job. You can't overcome that. What you can do is give them an opportunity to hear it, give them an opportunity to participate, right? So, to sort of go into this a little bit further, now that we're on that, let's talk a little bit about what is a code of ethics. So we sort of have talked about the role of the interpreter. We understand what we are supposed to do in general, but then we have these rules that we have to go by. Let's talk about now what a code of ethics is, what that means, what we're going to be dealing with today. So a code of ethics can be defined as the rules or standards of conduct governing the members of a profession, provides members and other interested parties with guidelines for making ethical choices in the conduct of their work, and really, we can call our code of ethics the cornerstone of our profession's credibility. Without the code of ethics, guys, we would just be little helpers. When you think about it, go do this, go tell them this, say hello, hi, how you doing? It was like that for a while in the interpreting profession. Over time, we've learned that it can't be that way. There are very specific parameters within which we have to work. And the thing about court interpreting, which is such a regulated area in the interpreting world, what I would say is that even beyond other types of interpreting, there are very specific rules that guide the work that everyone in court does, right? So everyone plays by these rules. And I sort of have come to think of it as, you look at court and you sort of think about it as a very defined, well defined game with very specific rules. And I don't call it a game to take away the importance of what we do, but this helps conceptualize it. So I see it as a game. I see the judicial process as a game from beginning to end. There are different players in this game. We have judges and we have defense attorneys and we have prosecutors, right? We have interpreters. Each of those players has a very specific set of rules. As long as everyone follows these rules, we might call these rules, besides a code of ethics, we might call these rules, I don't know, the rules of evidence. Yeah, that's what they are. They're the rules of evidence. So as long as everyone follows the rules of evidence, the process can go forward, the game can continue. When people break the rules of evidence, and a lot of times that means some type of breaking of an ethical principle, when that happens, the game breaks down. Bad things happen. There are consequences along the way. So our code of ethics was developed to complement the rules of evidence so that we work within these established parameters, and so that, again, we are respecting the integrity of the judicial process as it goes forward, right? So keep that in mind. That's an important way, I think, of approaching the work that we do and approaching ethics as we sort of move forward through our conversation today. So keep that in mind when you're there. You have a very defined role. The case will be able to move forward if you stay within your role. When interpreters break role, we'll talk about that more a little bit later. When you break role, bad things happen, right? Not just to you, bad things happen in the case itself. We can't do this. So let's take a question from Shivani here. So given the convoluted legalese the lawyers tend to use, even a native English speaker would have difficulty understanding them at times. That's a fantastic point. I certainly, as an interpreter, as somebody working to understand what they're saying so that I can put it in the right language, there are times when I've come out of court and not quite understood what's happened. It requires a lot of investigation on our part. I did not go to law school. I'm not an attorney and a judge, right? I'm convinced that sometimes attorneys and judges don't really know what they're talking about, right? So much less the interpreter. It takes very concentrated effort to fully comprehend the proceedings. Somebody not from this culture and not from this language can't really overcome that, even with the best of interpreters, right? All right, let's move forward a little bit. So there are different codes that are applicable to court interpreters. There are codes from professional organizations. If you're not a member of NAJIT, I would recommend that you reach out and you look into it. NAJIT is the National Association of Judiciary Interpreters and Translators. It's a great organization, right? There's no perfect organization, but they work really hard. And I think it's important to support them if you can. You should also look into something called the ATA, the American Translators Association. Fantastic organization. They put on a great conference every year. At least they did before coronavirus, right? Look into that. Those types of organizations create their own codes of ethics, and they're very similar to what we might have out in the field in each state, right? Those certainly could be applicable to what we do. There are also laws and regulations relating to interpreters. Kentucky has some specific laws related to working as an interpreter, specifically working in court as an interpreter. Those are important. They will vary from state to state. You need to find out what your state does. State codes of conduct for judicial employees, that's really what we're going to talk about today. We have a specific code of conduct for interpreters, court interpreters, right? You may be an employee, you may be a contractor. This code of conduct would apply to you. And beyond that, there may be general codes of conduct, for working for the judiciary that don't necessarily have to do with interpreting at all. That's important. Remember that you're working for a government agency and that the standards are very high. So there's court interpreting, and then there's just government standards. There's all kinds of things that come into the mix. Today, we're really going to focus on Kentucky's court interpreting code of ethics. We actually call it the Code of Professional Responsibility for Sworn Proceedings Interpreters. And we'll talk about that in just a few minutes to define what that is. So here's what we're going to cover today. We're going to do some exercises around these concepts. Depending on what state you're in, you would always see in that state's court interpreter code of ethics, you would see these things, right? In some variation or another, you would see these things. They may not necessarily be in this order. They may call them by different terms, use different words, but you're going to see these concepts, right? So we're going to talk about accuracy. We already mentioned that. That's important as a court interpreter. We'll talk about impartiality. We'll talk about the role of the interpreter, confidentiality, representation of qualifications, overcoming impediments to performance, professional demeanor and protocol, and continuing professional development. Other states, they might call them different things, but they're all in there. They may have an additional one or two that's sort of mixed into the ones that we have, or vice versa, but it's all in there. States really have the same canons from place to place. What does differ is how states interpret what this means. I may tell you accuracy is one thing, and in another state they'll say, no, it's not that, right? So we got to do it the Kentucky way, the bluegrass way. That's why we're here. All right, so let's talk about accuracy. We'll spend a few slides on this one because it's just really important, right? And I think that us now having so many interpreters from so many places, and many of our interpreters have practiced a long, long time. It's been a while since we've gone through an orientation style training. I think it's important just to get back to basics for a second, and let's talk a little bit about what accuracy really entails. All right, so accuracy, the canon's very simple. Interpreters shall be accurate and complete. Okay, well, that seems easy enough. All right, I got to say what they say. We're going to unpack that a little bit. Hold on. So why should our interpretation be accurate and complete? Well, there are many reasons, of course. Number one, the standard is, remember, equal footing, equal opportunity to participate. We're there to allow that opportunity. And when I say LEP, by the way, what that means is limited English proficiency or limited English proficient. So if the LEP spoke English, right, and they were listening in English, they would hear everything. They would understand, and let's don't say understand. They would hear everything, right, that's going on, and that's the same standard that we have as court interpreters, right? We have to provide access, language access. We have to open that door for them so that they can at least hear and have an opportunity to participate, and that means everything. And we'll talk a little bit about that in a moment. But if it's on the record, if the hearing has started, and there is speech that is audible, and an English speaker would have been able to hear it, you have to interpret it, even if it doesn't relate to the hearing per se. Even if the judge says, all right, we're on the record, this is the case of Mr. Joshua Elliott, case 1234. Before we get started, hey, secretary, did you see that game last night? Man, that was crazy. I'm going to do this case, but man, that game, I'm still thinking about it right now. Okay, we're back on the record. Let's get going. They just had this little crazy conversation on the side. An English speaker would have heard that. You're already on the record. You're live. You're on. Do you have to interpret it? Yes, you do. Absolutely. You should, right? So group exercise 1. Here we go. We're going to read through it together. And you guys are going to comment on the chat box and tell me what you think. So let's read through it together. The judge is speaking a mile a minute. You are trying to keep up but are unable to maintain accuracy due to the rapid rate of speech. You've missed a word here or there. At the same time, the defendant gives you a look that makes it obvious to you that he's not understanding what's going on. So you're speeding through it. You're doing your best. You've pretty much said everything, although you missed a couple things along the way. This dude doesn't understand really anything that's going on. We talked about it. Maybe that's important, maybe not, but there's some issues there. What do you do? What do you do? Let me see on the chat box. Take a couple of seconds. Let's see here. What do you guys think? And let me ask it this way. So thank you, Jill. Good to see you, by the way. Good to read you, I guess. So let's see here. Ask the judge to repeat. Ask for a lower rate of speech. Very nice. Request the judge to speak slower. Request a slower pace. I think we're on the same page. I may try the magic. Excuse me, Your Honor. The interpreter cannot keep up. Maybe. Okay, nice. So I think we're on the same page here. That's our general thought. And is that correct? Yes, absolutely. So we have no choice in this case but to ask for the judge to slow down. You must be accuracy and complete. There's an impediment here, and we'll talk about those later as well. There's an impediment that's preventing you from being accurate and complete. And what do you have to do? You have to overcome it. You do have to let the judge know, as Gabriela says. And so, how do you do that? Well, let's talk through it a little bit. Your Honor, Your Honor, forgive the interpreter. Your Honor, the interpreter is having difficulty keeping up with the court. Would it be possible for Your Honor to slow down a little bit? Maybe. Okay, let's try some other options. Your Honor, forgive the interpreter. Your Honor, the interpreter is having difficulty keeping up with the rate of speech. Could the interpreter ask His Honor to slow down just a little bit? Okay, possibly. Your Honor, forgive the interpreter. The interpreter is struggling to keep up with counsel. Would it be possible for counsel to slow down just a little bit? Okay, nice, diplomatic. I always try to put the responsibility, even though I'm obviously pointing out that there's a problem here, I always try to accept the responsibility that I can. I don't mind telling them that I'm having trouble keeping up. I mean, what I'm really thinking in my mind is anybody would have trouble keeping up. But right, I try to take that back and take ownership of that as the interpreter. Your Honor, the interpreter is having this issue. Your Honor, the interpreter is struggling to keep up because of the rapid rate of speech. Would it be possible for the court to slow down, or would it be possible for Your Honor to advise the parties to speak a little slower? Absolutely, right? We can also request a repetition depending on what it is, if that's what I need. Your Honor, forgive the interpreter. The interpreter did not hear the last comment because of the rate of speech. Would it be possible for counsel to repeat? Would it be possible for Your Honor to repeat the last section of what you just said? Absolutely, we can do that. Usually it's not so much a repetition that you need in this case, it's the fact that they're just flying. You want them to slow down. Now, pragmatically speaking, you ask them to slow down, and of course they're going to be nice. They'll say, yes, yes, of course. I'm so sorry, Mr. Interpreter. And for 30 seconds, it's going to be great. And after those 30 seconds, they're going to speed back up and they're going to start really rocking and rolling again. It's just the nature of the beast. But you absolutely should intervene and you should ask for them to go slower. That's going to be important, right? So, good deal. Accuracy. Court interpreters are expected to convey every element of meaning of the source language message without adding, omitting, editing, simplifying, or embellishing. You can't add stuff in that they didn't say. You can't leave out stuff that they did say. You can't make it sound nicer. You can't bring the level of language down. You can't dumb it down. You can't make it sound pretty, right? You have to say exactly what they said the way that they say it. And specifically, we must not alter the register of the source message. Let's define these concepts just one moment. We have register, which means the formality of the language, right? So when I talk about formality, there are different ways that we can say the same thing. For example, sir, I hereby remand you to the custody of the county detention center for a period of no less than 30 days. Okay, that's judge speak, right? He's sending this dude to jail. I hereby remand you to the county, the custody of the county detention center for a period of no less than 30 days. Okay. Or I could just say, dude, you're going to the slammer for a month. Same thing, same meaning, got the same message across, but it ultimately was received very differently because I lowered the register. I changed it drastically, right? Keep that in mind. That's an important point. So we must maintain that register to the extent possible, depending upon the language, right? Depending upon the language that's being spoken. Some things can't be perfectly maintained because of the discrepancy in the language itself. That's fine, but to the extent possible, we maintain it, right? Nonverbal messages, such as gestures, should generally not be translated. So they say something in a language you don't understand, right? They say, you know, blah, 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 blah. But they follow it with one of these, blah, 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 blah. You don't know what I said, but you know what I did. You understand the emotion behind it. I think you understand how I feel. I just have to add in the soundtrack as the interpreter, right? I have to tell you, add the words in, but I shouldn't, as the interpreter, say, yeah, judge, fuck you, mama, right? No, it would be awesome if we could say that. There are times when I've had to say that kind of thing to judges, but I'm not going to follow it with one of these. That might be a little bit much, right? So we don't add in the gestures. This can be especially difficult to recall, to remember, when there are culturally bound gestures. Okay, and what do I mean by this? In some cultures, you know, there are gestures that just mean certain things. In American culture, if I do this to you, you know what it means. If I do this to you, you know what it means. It's peace, right? Maybe either one of these. You're like, hey, peace, peace. In Australia, did you know if I do this, you know what it means? It means the same as this means. Okay. Those are culturally bound gestures. They mean different things in different places. So let's say that a culturally bound gesture were used. Okay. And you know what it means because you've studied that language and that culture, you understand. Nobody else in the room knows. There was some meaning behind that, right? Should you interpret the gesture? No, traditional court interpreting would tell you no. And typically in Kentucky, I would encourage you not to do that. I think we get into trouble when we do that because although you may think you know what it means, and you may very well know what it means, you're just never sure what the intentions of the person really are, right? So be careful with that. One example from the Spanish language that we see frequently, I had this come up in court once. The lady was telling the deadbeat husband, you're a deadbeat and you're cheap and your kids are going without because you don't pay your child support. And then she looked at him and she does this, right? You, what does that mean? Spanish speakers, what does that mean on the chat when they do this to you, right? Let's see, what does it mean? What do you guys think? That's right, it means cheap, stingy, right? Because the word for elbow in Spanish, which is codo, it also can mean like cheap, stingy, miserly, right? And so they have those two things together. It probably means that, right? But Nidia says it depends, and it absolutely can depend. Depends on the situation, depends on the country, depends on what's being said, on the intent of the speaker. Probably means cheap, but maybe it just means, was it this or was it this? You don't know what it means. Be very careful. Okay. So I want you to tread very, very carefully when you're doing these types of things. We can certainly express some emotion in our interpretations, but it needs to be done with limitations. Bring it down, right? The lady is upset. She's crying. Somebody tried to kill her. She's distraught. Everybody sees that. You add the commentary. There can be intonation in your voice to follow along, but in the end, you don't need to mimic. If we're not careful, we can make something that was not supposed to be funny quite humorous, right? The lady comes out and she says, yeah, he tried to kill me and he had a knife and I thought I was going to die. And hear the interpreter, I'm standing by her and I'm going, yeah, he tried to kill me and had a knife and I thought I was going to die. No, it's funny all of a sudden. People laugh at me and it's not a laughable thing. So bring it down. Maybe my interpretation is, and then he came out and he tried to kill me and I thought I was going to die. There's some emotion, there's some intonation there. I'm following her intonation, but bring it down 50, 60, 70%. Bring it down, right? So we want to be careful. Accuracy and completeness. How do we do this? Just some examples. We maintain register. We talked about that. Legal, slang, acronyms. Best word choice versus nuances, or the correct versus the best option. So what I mean by that, there may be several different ways to interpret something into another language. All of them can be right, but there will be one way that'll be the most correct answer based on the context of what you're hearing, right? For example, we have the word round. Round means round, means circular, goes around, right? It means round in all cases, except when round means bullet. He had 3 rounds. He shot 3 rounds. Well, he shot 3 times. He shot 3 bullets, right? Depending on the context of what is said, it may mean this or it may mean the bullet itself. You have to determine what the correct interpretation is based on the context. Context is all important in the work that we do. Obscenity is part of the job. Some people might say they're the best part of the job. I don't know. Really, you guys tell me. It's what we do. They pay me this. I got to say it, right? Somebody cusses out the judge. I got to cuss out the judge. You should be comfortable with that. That's just what we do in court. It would be unacceptable in Kentucky and any other place, I might imagine, actually, for an interpreter, a court interpreter to say, Your Honor, the defendant is using vulgarity, right? The court interpreter, the defendant says something like, Su señoría, chinga tu madre, right? Your Honor, the defendant is using bad words. No, you got to say it. You were tested on that. And our certification exam even test you on that. You got to say it. You got to look at the judge in the eyes and you got to say, Your Honor, fuck you. That's what you got to say. You got to do that. And if you don't do that, it's a disservice, right? And you're getting paid to do it. So you just got to do it. You got to let it go. And you may say, well, Joshua, my religious beliefs don't allow me to. Well, we have to do this. This is the profession that we practice. If you get to a point in which you're uncomfortable with some of the basic ethical guidelines and responsibilities that we have, we probably have to look at for another profession, right? The good news is it doesn't happen all that often, but I do need you to be comfortable with these types of things when they come up. If you interpret in family court enough, it's bound to come up. Domestic violence is going to probably come up frequently. And these things are important to know and important to be able to to interpret when they do happen. Idioms, culturally bound terms, and units of measure. Let's talk about it just a little bit. Remember always that underlying meaning is what's most important. Look, on our chat, by the way, guys, Cecilia, who's our wonderful Romanian interpreter, she's out. I'm really enjoying this. I bet you are, Cecilia. That's fantastic, man. I'm glad. I might say to you, fuck yeah, we're enjoying it. All right, good. I didn't say that. I'm a court interpreter. It's okay. It was in my ethics. All right, let's go forward. So, idioms, culturally bound terms, and units of measure. Let's talk a little bit about idioms. Underlying meaning is always important in all of these things, all the things we're talking about here, but with idioms specifically. So you have an idiom like cool as a cucumber, right? It's an idiom. As a native English speaker, I understand when you say that what you mean is the guy was just very calm. He was laid back. He was not nervous. He was the opposite of nervous. He was very, very calm. He was chilled, right? He was chill. He was chill. He was chilled out. Okay. All right. So how do I get that in the other language? If I do a word for word translation, probably means nothing, right? In Spanish, if I say this, right? If I say cool as a cucumber, literally, I say, él estaba tan frío como un pepino. I say that. Those are the literal words for cool as a cucumber. Means nothing, right? Any native Spanish speaker would listen to that and they would just, what does this mean? What's happened to him? Is he okay? Did he die? Why was he like this cucumber that you say? Right? It means nothing, makes no sense at all. Now, if I say to them in Spanish, what our wonderful friend Greta has said, Greta, good to see you, by the way, today. If I say to him, fresco como una lechuga, right? Más fresco que una lechuga. Right? If I say something like that, they're like, oh, that's what you meant? He's fresh like a lettuce. That's how they say that in Spanish. There may be an equivalent idiom in your language. If you know the equivalent idiom, and it's like this one, it's a common one, and you can bust it out pretty quickly. Okay, use it. It's good. You should be doing that. Okay, use it. If you don't know the equivalent idiom, is it okay for you to simply explain the meaning? I don't understand I don't know how to say cool as a cucumber in my language, but I know what it means in English. Can I just tell them that it means he was very calm? Can you? Yeah, absolutely. Not only can you, you should. You should do that. That's really the way to resolve these types of issues. And some things, some idioms simply have no equivalent in the other language. We say some weird stuff in Kentucky. Well, boy, you better take that deal. Those deals from this prosecutor are rare as hen's teeth. Rare as hen's teeth, because hens don't have teeth, right? Try saying that in your language. Doesn't make any sense. You just have to say they're extremely rare. They're just uncommon. They're unheard of. They don't happen, right? You would have to sort of repackage this a little bit. It's okay. Now, there's a term, culturally bound terms. For example, sushi, right? I think I have some Japanese interpreters on here. I know Shivani's here. I think I saw Kiko on here as well. So we have sushi. You guys know what sushi is. I love sushi. I can eat my weight in sushi. If you say sushi and I have to interpret it into Spanish, I don't change it. Sushi is sushi. I don't say, you know, delicious raw or slightly cooked fish with wonderful rice and wasabi sauce and soy sauce. No, I don't say that. I just say it's sushi. A burrito's a burrito, right? Okay, that's what we got. Those terms are maintained from one language to another. Now, things that we might have to convert: meters, gallons, inches, pounds. Do we convert them? How tall are you, sir? 1.86. 1.86. If you say that to a native English speaker, especially one perhaps who hasn't gone out of the US, I'm 1.86 tall. What? What do you mean? Was he little? Like he's a little guy. He's like this tall, like a real little dude. No, that's not what they mean. He's 1.86 meters. Just let it work itself out. How tall is he? 1.86. He's 1.86. The attorney will say, what do you mean? 1.86 what? You interpret. What do you mean? 1.86 what? Let it work its out. They're meters. Oh, meters. Oh, okay, right. How tall are meters? I don't know. What happens if you say, you know, give you an example. How long was the knife? The knife, I would say, was about this long, right? And the interpreter says, yep, the knife was about this long. What are they going to do? Your Honor, for the record, the interpreter has indicated the knife was approximately 1.5 feet long. What? I don't know what it is. Let this stuff work itself out. All of these gestures, idioms, conversions, don't do them right. We just let these things run their natural course. And I promise you, these things will work themselves out. And if they don't, and if you interpret it correctly, it's okay if they don't. I said it, right? If there is confusion in the end and you've done your job correctly, you didn't cause that confusion and you have no responsibility to clear up the confusion. Those things have to work themselves out in court. Generally speaking, judges and attorneys are smart enough to get that done. If it doesn't happen, there's nothing you can do about it. That's not your role. That's sort of a hard lesson for some people sometimes, right? So Hank says, do you gesture the size of the knife? You do not, Hank. You don't do it. No. So the guy says, you know, how big was the knife, sir? He says, the knife was this big. My interpretation is this. The knife was this big. That's it. That's what I do. You know, how far was it? Oh, it was, you know, way over there. It was like from here to that wall. My interpretation. How far was it? Oh, it was way over there. It was like from here to that wall. That's it. That's what I do. You could literally do this job with your eyes closed. Keep that in mind. Literally, right? I met an interpreter. I was in Miami. You know, I took a position in Miami for almost 2 years there. I was a staff interpreter. I was a supervisory staff interpreter with the federal courts in Miami. And I met an interpreter while I was there who was very interested in becoming federally certified, and she was blind. She was born blind. And she came in, and I gave her a practice exam. Fabulous interpreter, top notch, unbelievable. Couldn't do sight translation, right? Because she can't see. Her consecutive was just off the chain. Excellent. She passed that federally certification. That federal certification exam. She's now federally certified. You can literally do this job with your eyes closed. All right, keep that in mind. All right, accuracy and completeness, let's keep talking about it. If it's convoluted, if it's nonsensical, doesn't make any sense, it's random, it's crazy. You literally are interpreting for somebody who is insane, quite literally insane. You have to say it. You have to say it the way that they say it. Don't make sense of it. It will make no sense. You can't say it the way that it's said. Filler words, or what we might call in English hedges, right? Well, I mean, all of those things have to be included in your interpretation. You know, in Spanish, if you say to me, in Spanish, I'm probably going to say bueno, pues, right? All these words, you got to know them in your language in order to put them in. That's important. Other forms of interpreting, you wouldn't necessarily need those. Conference interpreting, you try to make the speaker sound more elegant. You omit those things on purpose. In court interpreting, it's important because it goes toward the credibility of the witness. Keep that in mind. Forms of address, make sure that you're familiar with them. Ma'am, your honor, um, counsel, right? Madam counselor, any of those things. Make sure that you know how to say those in both languages. So our challenge, not to use the same words, but to relay the appropriate meaning. Meaning for meaning, right? Words are simply there to convey, I think is that my next slide? No. So words are there to simply convey concepts and meanings. We really, as interpreters, we deal with meaning. We deal with concepts, underlying concepts. The words are very secondary. I need you to get all the concepts from one side to the other. If it takes more words or less words, that's fine. It probably will take more words. English is actually a very efficient language. It crams a lot of information into each syllable. A lot of semantic data goes into each syllable in English. When I take that information from English and I pass it into my language, my B language, which is Spanish, Spanish is not nearly as efficient. So it takes me more words, typically speaking, more syllables to say the same thing. That causes me to have to speak faster. I've got to use more words. That's fine. If you can say it in a more efficient way, if it takes less words when you go from language A to language B, fantastic. You win. You're ahead of the game. Usually not the case, but it could be. There are some instances of this, right? But get away from the number of words or what the words themselves are. I want you to deal with the concepts and the meaning from one place to another. Okay, so keep that in mind. That's going to be important. So just some ideas here, some examples. This is where we interpret for meaning. These are idioms. To fly off the handle, that doesn't mean that you were sitting on a handle and you flew off of it, right? That means that, you know, you lost your temper, is what it meant. To let the cat out of the bag, I hope you're not abusing the poor little kitty cat by keeping him in a bag. No, it means that you revealed the secret, maybe that you shouldn't have revealed. To step up to the plate, there's lots of sports terminology that we deal with. It comes into American cultural speech a whole lot. Step up to the plate, you're at a baseball game, the batter steps up to the plate to bat. It means, okay, you're going to take your responsibility. You're going to own up to whatever you did. You're going to, assume the responsibility that you should have taken on to begin with. You got to step up to the plate. You got to get it done. 3 victims have come forward so far. They probably didn't physically step forward, right? Means that they've testified, they've contacted the authorities. To drop the ball, another sports reference, means you didn't do what you're supposed to do. Don't hold your breath means you probably shouldn't wait for that. You shouldn't expect for that to happen, right? If I were you, I wouldn't hold your breath because you would die waiting for that to happen. Is where it's getting at. Don't expect that to happen anytime soon. Pushing the envelope. What that means is you're always pushing the rules. You're not quite breaking them, but you're always going a little too far, right? You're always pushing the envelope here. You need to stop that or you're going to get into trouble. These are examples. You're going to have to interpret for meaning, for concepts, instead of looking at the words per se, right? Some examples of register. All of these means the same thing. Okay, all of them. Shall we depart? Would you like to leave? Should we go? Want to take off? What do you say we blow this popsicle stand? I have no idea who wrote that, by the way, but that's what it means. That means that's all of them means. Do you want to get out of here? Do you want to leave? Are you ready to go? Any of these would mean the same thing, different registers, right? I'm not sure though. You go up to somebody, you're in a bar, and you're like, "Hey, what do you say we blow this popsicle stand?" I don't know how that would go for you. You should try that. Let me know if you've done that. I want you to contact me and tell me how it went. All right, let's go to the next canon, please. Impartiality. Interpreters shall maintain an impartial attitude with attorneys, witnesses, defendants, and relatives. Interpreters shall be unbiased and shall refrain from any conduct that may give any appearance of bias. They shall disclose to the appropriate authority any real or perceived conflict of interest. So very interesting here. It's not just that you have to maintain impartiality, right? Don't do anything that would be unethical or partial towards one of the sides. It's not that. You must go farther. You must avoid even the appearance of a conflict of interest, the appearance of bias. True story. This was quite a few years ago. I was in Louisville, in Jefferson, where I was a staff interpreter for years, sitting in my office, and they called me to do a witness for a trial. We didn't know about the trial. Nobody had scheduled us. We weren't there. So they called me up. They're like, "Can you help?" Okay, I'm going to help. All right. So I walk in, had no idea what was going on, didn't know any of the parties, knew nothing about this trial. I walk in, and as soon as I walk in, the attorneys look back at me and they see me, and one of the attorneys, the defense attorney, she gets up and she asks the judge if the attorneys may approach the bench, right? Before I sort of, take my spot. And she went up and she talked to the judge, and then they sat back down and they let me proceed. I knew exactly what she was doing, because if she didn't do it, I was going to have to do it, because that attorney is a friend of mine. We actually went to high school together. I didn't know her very well, but we see each other occasionally. We say hello, how you doing? How's your family? That kind of thing. We sort of have that out of court interaction relationship, right? Probably nothing to really worry about, but could it cause the appearance of a conflict of interest? Yeah, it could. If somebody knew that, or if somebody saw us outside of court talking about that, they may say, "Hey, wasn't that the defense attorney, and isn't that the interpreter that they used? Was there something strange there? Was there something going on? Maybe he helped them. Maybe he likes her. Maybe somehow they worked together on this." Right? It's the appearance of a conflict of interest that we have to avoid. And so she talked to the judge. The judge says, "Okay, this is fine. I'm comfortable with this. Let's move forward." I interpreted there was no issue, right? But we have to work to avoid those types of problems. We at least have to work to disclose to the appropriate authority when we feel there could be a real conflict or a perceived conflict. That's really important. Don't take it upon yourself to make that decision. If you're questioning something, if you're saying, "Well, should I or shouldn't I want you to be on the conservative side. I want you to err on the side of caution, and I want you to bring it up to somebody. If it's before court, you should call. You should call Armada, our operations manager. You should call your liaison, whoever you're working with. You certainly can call me. You can email us. Ask about it. Bring it up. Mention it. If it's in court, who do you tell? Probably the judge, right? Approach. Your Honor, may the interpreter approach with counsel? Your Honor, forgive the interpreter. I just realized I know this defendant. I just realized now I interpreted for this defendant outside of court in this situation, or I'm friends with his mother. We've had dinner together. How would the court like to proceed? Whatever it is, let the court know, let us know, and we'll decide for you. Don't take that upon yourself. Interpreters get into trouble when they try to do that. It's probably fine. You probably can still interpret. Let us help you with that. All right. So let's do an exercise here. Exercise number 2. Okay. You are in arraignment court. You're sitting beside the LEP defendant, waiting for your case to be called in arraignment court there. The defendant asks you to please call his mother, who's very ill and is probably worried to death and suffering because she doesn't know where he is. Furthermore, he explains to you that the phones at the jail just don't work. He then proceeds to give you his mother's telephone number. So, what do you do? And specifically, what I want from you is, do you contact the mom or not? Yes or no? Show me yes or no in the chat box. Let's see it. Yes or no? Okay, I'm seeing some no's. I see a nope from Salson. Okay, thank you, Salson, my friend. It all says like nope. Okay, good. Okay, I know you're all saying that. I know somebody else sitting out there going like, "Yeah, I would totally call the mom." Okay, I know there's somebody out there. Okay, good. We're on the same page. There are some problems here, right, with this scenario. Of course, you don't call the mom, but there's an issue here. And Nydia, you hit it right on the nail right on the head. You shouldn't have been sitting beside this defendant to begin with, right? You put yourself in a very difficult situation. It's impossible almost for there not to be some communication or at least the appearance of a conflict of interest. And you think about this conversation that took place here. Think about this. You're sitting there, it's very innocent. Really, you're not giving inappropriate information. You're not sharing, secret information or trying to help. This person's just saying, "Hey, can you call my mom?" And maybe you even say, "No, I can't call your mom. I'm sorry." And you're saying that in your language, right? If it's me, I'm speaking in Spanish. "No, I can't call your mom." But no one else in that room speaks my language. The judge doesn't speak my language. And the judge from the bench sees me talking, sitting beside this person and sees me talking to him. And maybe he doesn't think much about it, but he's like, "That's very strange. I wonder what that interpreter's doing. I wonder what they're talking about. I wonder if he's giving him legal advice or something." It causes the perception of some bias. Certainly, at least it makes somebody question, right? Be careful. I want you to go in Kentucky, and I would say everywhere because we're right. Kentucky's always right about this. But I want you to go to great lengths, to a great degree, to avoid these types of interactions. If the defendant is sitting there, you should stand someplace else. You should sit someplace else. If the defendant goes out one door, you should wait till they leave. You should go out another door. If the defendant is in the elevator, you should wait for him to go down. If the defendant is in the bathroom when you get there, I want you to turn around and walk back out. Right? I want you to go to great lengths to avoid the perception of a conflict of interest. That's important, right? I want my interpreters to be interpreters, and that's it. I want defendants and their attorneys to interact without our input. That is it, right? So I want you to be really, really careful with those types of things. Now, Shivani brings up a good point. If this happened to her, she would give it to his lawyer, potentially, maybe, right? If you were in a situation and you couldn't avoid it, can you call my mom? Sir, I cannot call your mother, but all I can do is tell your attorney. Counsel, he has a question. Can you call my mom? I would pass it over. Okay, maybe they don't have an attorney. Exactly. It's an arraignment in this case. There's no attorney. There's nobody to talk to. In that case, maybe I could say it out loud to the judge. "I can't assist you. I'll tell the judge when we go in front of the judge." Right? Maybe I could do that. "I can't assist you. Here's a bailiff. Bailiff, can you call my mom?" Let's see what that bailiff says. Okay. Really, you shouldn't be talking to that person in the first place. If no one else is speaking, you have nothing to interpret. You're not there to interact. Remember, you're there to interpret. If there's no other representative from the court or an attorney speaking on the record, there's nothing for you to interpret. You shouldn't be there interacting. So keep that in mind. I want you to go to great lengths to do that. All right. The interpreter may not express, let's talk about impartiality a little more, show, or even appear to show partiality for or against a party in a case. If an interpreter has emotions, beliefs, or opinions that are so strong that they may affect his or her performance, then the interpreter should ask to be excused. Conflicts of interest, real or perceived, must be avoided, right? So this could take a lot of different forms, of course. Maybe the attorney comes up to you and says, it's after the trial, you've been interpreting, and you like this attorney, you're sort of friendly with this person outside of court. "Hey, how you doing?" That kind of thing. And they say, "Man, I'm glad that's over. The jury's deliberating. What do you think? Do you think I won? What do you think? How do you think it's going to go?" Can you do that? You can't do that. You can't tell them your opinion. You may have an opinion. You know, we're human. We're sitting there through the whole thing. You try not to form one. I would tell you, as an interpreter instructor, you shouldn't have an opinion on these things. But let's get real. You do. Right? But can you share it? You shouldn't. A good way out of that is, "Oh, counsel, you know that I can't tell you that." Or, sometimes I've said, "Juries are just the craziest thing. You just never know." Right, and walk away sort of quickly. You can't do that. You can't share that experience. This includes personal opinions, right? You must maintain your neutrality at all times. Obviously, we're talking about conflicts of interest here, interactions with parties in the case. You shouldn't be talking to attorneys on either side. You shouldn't be talking to defendants or victims on either side unless you're in court and they are testifying from the witness stand formally on the record, right? There should be no interaction. In Kentucky, and we're getting into our next point here, we have something that we consider, a very defined role of the court interpreter. And if you break that role, there's a conflict, there's a role conflict. And so by you helping either side when you shouldn't, you're breaking role and there's a conflict arises, right? So we're going to talk about that a little bit now. This will be a little bit eye-opening, I think, especially for our interpreters who are here from other states. I very strongly believe that we do this right. And I think that we're seeing more and more across the nation that court court interpreting is going this way, because I think it has to, because what we're describing lines up very well with those rules of evidence. States that don't do it this way end up with procedural legal problems at some point. Something's overthrown, something is thrown out because the interpreter broke role. So what we're going to describe now is this role of the interpreter, right? After, of course, we do group exercise number 3, I should say. So group exercise number 3, let's do it. You're interpreting on the witness stand for a defense witness who happens to be an accountant. Okay, smart guy. He's testifying about tax documents, which are foundational in determining the defendant's financial solvency and legal business operations. Important stuff. Since you have interpreted for this defendant and his attorney outside of court, you're sure that the documents presented as exhibits are fictitious. You're on the stand, you know the dude's lying, the document is fake. What do you do? And yes or no, let me see. Do you tell the judge about it? Yes or no? Let's see here. I see some no's. Okay. Those no's were not as quick to come through as the other no's, though. You guys were thinking, you're like, I don't know, maybe I should do it. I don't know. So I see all no's. Okay, that's obviously the right answer here. So let's see here. Yeah, Jill says no, you just got to interpret. Okay, good. Anar says, nah, I can't do it, can't do it. All right, so let's see here what we have. Some problems with this one, right? So you apparently assisted the defense attorney to prepare the case. Somehow you interpreted outside of court, you've interpreted during their attorney-client communication, you're aware of this case. And then for some reason, you've ended up on the witness stand in court as the impartial court interpreter. Huh, that seems strange now, doesn't it? Can you really be impartial after you've interpreted for the defendant? I don't know. I don't know. We need to talk about that a little bit. It's very strange. Hank says you need to disclose. Definitely there needs to be some disclosure here. In the best case scenario, if I get there and realize what's happened, or they ask me to interpret in this case, and I know up front, hey, it's this case I've done, I certainly should disclose. Your Honor, I'm happy to interpret. I do have to disclose. In the interest of full disclosure, I want to tell the court that, I've done this. I've interpreted outside of court for this case, for case preparation. I've been involved in attorney-client privilege communication, and I've received payment from this attorney or from whatever agency it was to help prepare the case outside. So do you see the issue? You've received payment from another source, and now you're in court, and the court's going to pay you as well on the same case. The court's paying you to be impartial. Is there the perception of a conflict there? There's at least the perception for me. I'm uncomfortable generally with this. You want to be careful, right? So let's talk about this just a little bit here. Let's go forward now into the interpreter's role in judicial settings. So we're going to talk about 2 different things. There are more roles than this. We're going to talk specifically about these 2. I want to make sure, if nothing else in this presentation today, you guys understand that, understand this description, okay, this differentiation of roles. We have what's called the sworn proceedings interpreter. And you guys remember at the beginning, I mentioned that our code of ethics is actually called the Code of Professional Conduct for Sworn Proceedings Interpreters, right? And that person is what we think of as a court interpreter. That person goes to court, hired by, in our case in Kentucky, the administrative office of the courts, paid by us, right? The Office of Language Access calls you, we schedule you, you go to court and you interpret in court on the record a hearing, a proceeding, right? Something like that. That's the court interpreter. We call them a sworn proceedings interpreter. And then there's this other thing called a private linguistic expert. This has many different names. You might hear it called the table interpreter or the check interpreter, right? Because they sit at the table, the defense table or the prosecution table with the attorney. You might hear it called the monitor interpreter because part of their job is to monitor or check the interpretation of the sworn proceedings interpreter. You might hear it called the party interpreter, right? Because they interpret for the parties. It's not that they're cool and they're partying. It's not that. You could call it maybe the defense or prosecution interpreter, right? But this is somebody who is hired by one of the sides, or maybe both sides might have an individual interpreter, but hired by and paid by the different sides versus the sworn proceedings interpreter who is in court interpreting on the record, who's supposed to be impartial, right, being paid directly by the court. So we have these 2 different roles. What happens is that sometimes, in some places, interpreters do both of these at the same time. You fill both roles. You go to court and you just interpret everything that's there. You're in court, you interpret for the judge, and you're on the record, and then the attorney says, hey, can I grab you? Can you come out in the hallway for just a moment? 5 minutes, let me talk to my client. And you do. And then the prosecution says, hey, we also have a victim in that case, same language, can you help me? And you do. And so you interpret for them. And then you go back into court in front of the judge. Do you see the issue here? Even if you're only being paid for by the court in that case, is there the perception of a conflict? Could be, certainly. Have you found out more than you should know? Could it affect on a real level? Could it affect your impartiality? I would argue that it could. It very well could. Even without you meaning to do so, the information that you've received on both sides can't help but somehow affect. It can sort of tinge the way that you are interpreting, I would say. You have to be very careful about this kind of thing. Let's talk a little bit more about it and define these in a little bit more detail. So let's talk about the sworn proceedings interpreter again. I'm going to point out some differences. When you interpret for us, I want you to know that there's a difference between doing this type of work and then working for an attorney, working for, another party. So when you're interpreting for us as the sworn proceedings interpreter, what are you? So you're under oath, means you have taken an oath to interpret accurately, right? Professionally, ethically. You guys know this in the contract process, you have to sign that oath. And sometimes in court, they give you the oath again, but that's what this oath is. You are under oath. That's an important oath to provide accurate interpretation and to do so impartially, essentially, right? Okay. You're an officer of the court. What does that mean? Officer of the court, we'll actually define that in a moment, but means that you are responsible for making sure that the law is followed to the extent possible within your role and that things go the way they're supposed to go. In your case, as an interpreter, you got to stick to your ethics, right? You got to follow the rules. You are an extension of the bench, as we mentioned, right? So primary function is to provide assistance to the court, to the judge, to the judicial system in communicating with, well, everyone, right? All of those LEP individuals that are participants in the process as well. That's your primary function. You don't work for the attorneys. You don't work for the non-English speaking or limited English speaking parties, right? You work directly for the court. You work for, in most instances, we might say the judge. You want to make sure to facilitate that communication, not so that there is comprehension, but so that there's an opportunity to participate. That's your job. And when you are acting as a sworn proceedings interpreter, you are bound by the rules of evidence. And we talked about those parameters, right? So our ethics keep you safe and make sure that you follow those rules of evidence. When you do things outside of our ethics, you could potentially break a very important rule of evidence, rule of judicial procedure. And in doing so, you could accidentally probably cause some really negative consequences down line, right? Because you did this, now the case is affected negatively later in this way. You don't want to do that. You don't want to be that interpreter, right? So let's see, let's go to some questions here. Shivani says, isn't there a conflict of interest to interpret in this case? Yes, absolutely. There would be a conflict of interest in the case we just talked about. Rekha, and good to see you, Dr. Gupta. Thank you for being here. The attorney asking for interpreting services before or after the proceeding. Very, very common, Rekha. We try in Kentucky to avoid that to the extent possible. If we have to do it, in the best case scenario, if I do it, I need to disclose. I need to get the judge's permission. And we actually have specific rules in place in our ethics that say that judges should not ever let us do that. If they do order us to do so, we should do it, but I want to know about it. I want you to follow up with Armada. I want you to follow up with me and we'll handle it on the back end. Shouldn't happen, right? Let's see here. I'm going through just some questions here real quick. So contract terms are also deemed, contract interpreters also deemed officers of the court, correct? That's absolutely correct, Cecilia. When you are working for us under contract, in the contract really, you're taking on the role of the sworn proceedings interpreter who is an officer of the court for sure, right? So Nithya says, why are we the only officer of the court that can and sometimes are sworn in every time we do our job? No other officer of the court is assumed to have such a terrible and short memory. That's a good point, Nithya. We'll work on that. Now, I can tell you all of the officers of the court there, and we're talking about attorneys and bailiffs, right? Judges, right? They are all sworn in, but they don't do it every time. You're absolutely right on that. Now, many judges do not swear our interpreters in every time. You do take the oath. We have it on file, but they just feel better. Actually, to be fair, there is a rule. We talked about those laws in Kentucky that deal with interpreting. There is a law in Kentucky that says that the interpreter shall be sworn in. We do swear you in. That is sufficient to meet that law, to follow that law. But judges knowing this, they will swear you in. So to be fair, that's why. But you make a good point, Neely. I think it's almost, it's not exactly a racism, I guess, but it's some type of discrimination against interpreters. Absolutely, right? So anyway, let's go forward here. So we're good to go. Officers of the court, let's talk a little more about that since we're on that topic. It's a person who's charged with upholding the law and administering the judicial system. You have a responsibility in court just to make sure that things work the way they're supposed to work. In our cases, that means that you need to interpret and not interact with the other parties. You can't break role. That's what this means. You need to follow your codes of ethics, right? Other officers of the court, judges, attorneys, clerks, bailiffs, sheriffs, and of course, our sworn proceedings interpreter. Now, keep in mind, let's go through the definition on this. Sworn proceedings interpreters have taken an oath, the famous oath we just talked about, and this definition is directly from our administrative procedures, by the way, has taken an oath to provide complete, unbiased, and accurate interpretation, language access services, we might say, between English speakers and defendants, litigants, victims, or witnesses with limited English proficiency or who are deaf or hard of hearing during court proceedings or direct services, right? So you've taken this oath. And then number two, and you guys didn't know this, especially you guys outside of Kentucky, you're like, I signed the contract, but I didn't realize this. This is important. Let's talk about it. So you are an impartial officer of the court and may not, this is in the actual definition of our administrative procedures, you're bound to this, you may not participate in the facilitation of private and or privileged communication between non-court of justice entities and individuals with limited English proficiency or who are deaf or hard of hearing. And some of you out there, you're like, what? What is this about? So actually, our administrative procedures, which are orders from the Supreme Court of Kentucky, they state that we cannot, we must not, we shall not participate in this private privileged communication between attorneys and their clients. And there are different reasons for that. First off, it's just a breaking of role. We're not responsible for providing helping attorneys effectively communicate with their clients. We're just not. They have that responsibility. And it costs us money to do so lots of times, right? Sometimes it wouldn't because it's within the 2-hour minimum, but not always. A case can be extended long beyond the 2 hours and we would pay for providing the service that we're not responsible for. But even beyond that, interpreters really, this is something that I think most states fundamentally don't understand, right? Interpreters really are not included in the attorney-client privilege, especially when you're working as a sworn proceedings interpreter. The court has paid you for your impartial services. You come to court, you are the court's resource. You work directly for the court. You're an officer of the court. An attorney pulls you in the hallway and uses you for privileged communication. You're the court's resource. There's no expectation of privacy when they use the court's resource. If you use the court's computer because you forgot your own, and you leave important information on that computer, and later somebody else who borrowed the court's computer finds that information, and they somehow benefit from that information, can you really be upset about it when there was no expectation of privacy because you used the court's computer? Same thing with the interpreter. I'm not saying that you would turn around and reveal the information, that you would disclose the information knowingly. But what I am saying is because of your role as a sworn proceedings interpreter, because you had a very specific set of parameters you were supposed to work within, and because you broke that role and did something outside of your role and you interpreted privileged communication, you wouldn't willingly tell that information. But there are some procedural consequences. And could the opposing counsel potentially force you to disclose on the record what you heard during this privileged communication? Yeah, absolutely. You weren't part of that privileged communication. There was no expectation of privacy. That's why this exists, to avoid those downstream procedural consequences. Must be very, very careful about this kind of thing, right? Different states interpret this in different ways. I feel very strongly that we have this right. I think that we, again, are forerunners in this type of conceptual understanding of the role of the interpreter. I think it's very important that we adhere to this, right? Now, there are ways potentially around it. States can potentially pass laws to make it where that can't happen. And okay, let's say that happens. In Kentucky, there's actually something that says that the interpreter is protected, can't be called as a witness. Okay, well, let's say that's the case. Well, it's still best practice. In the end, it's still best practice because really, it's more than just a conceptual issue, right? It's more than just, hey, they might call me and I'd have to tell them. Well, it's bigger than that because it's an actual real conflict of interest. Because I would argue that you can't really maintain your impartiality when you've essentially assisted the defense in preparing the case, and you've assisted the prosecution, maybe even on the same case, in talking to the victim, and then you come back into court, those things can't help but affect to some degree your interpretation, right? How you consider things, your body language, the words that you choose, even subconsciously. I want you to be very, very careful when you do this, especially in Kentucky. So I want to make sure that we understand the requirement here. This is a very important point. The judge may order you to do so. If the judge asks you to do it, what I want you to say is, Your Honor, may the interpreter approach. Your Honor, the interpreter will do whatever the court orders him or her to do. However, in accordance to our ethical guidelines, the Supreme Court has prohibited this interpreter from facilitating privileged communication outside of the presence of Your Honor. How would Your Honor like to proceed? You might even take a copy of the administrative procedure with you, which I will send to you soon so that you have it. I'll send it when I send out the recording. Keep it with you. If they say, what do you mean? I've never heard that before. Well, show it to them. Our judges are typically aware of this. We have talked about this for a while, and we've had some nice heated debates about this, I would say, along the way. We won this battle. All right. So we have a Supreme Court order that says that we shouldn't do it. Now, if a judge orders you to do it, I want you to do it. I want you, after disclosing to the judge what your ethical limitations are, I want you to do it. And then I want you to follow up with me, follow up with Imarna, and we will address it behind the scenes. In most cases, this works very well. There's a specific instance in Kentucky that we're trying to resolve where this rule makes it really difficult for judges, and we understand that, and we're sympathetic to judges for that. And so I want you to do what the judges tell you to do, but I want to know about it, and I want to make sure that that the judge and I and or Marta that we talk a little bit to make sure that we're on the same page. All right. So let's go forward just a little bit here. So what role do you play? What if you're the private linguistic expert? So let's talk about the other side of this. You're not working for the court. You're the private linguistic expert, which means you're hired by the defense. You're hired by the prosecution. Okay. What is that person? Well, that person's not under oath. Even if, let's say, you are a contract interpreter here in Kentucky, you have a contract with us and you've signed our oath. But let's say an attorney calls you up and says, hey, I need an interpreter, a private interpreter to help me prepare the case. And so you do that. Sometimes you're a sworn proceedings interpreter with us. In that case, you're under oath, you're an officer of the court, all the stuff we just said. But sometimes you're not. Sometimes you are playing another role. You are hired by another party to do a different job. That's this job. That's the private linguistic expert. In that capacity, you're not under oath with us at that moment because you're not a sworn proceedings interpreter at that moment. The way that you approach that job is a little bit different. There are similarities, right? The same level of accuracy exists. I find that this private linguistic expert role is gives a greater degree of flexibility. It allows for other services to come into play. You may be a cultural expert in regards to people that speak the foreign language that you speak, and you may offer that type of knowledge to the attorney when you're providing these private linguistic expert. I'm totally fine with that. I think you should do that, right? You may do transcriptions and translations. You may comment on the validity of another interpretation. You can monitor the sworn proceedings interpreter. There's lots of different things you might add here. You may have knowledge that is helpful to that attorney. You're still impartial. I want to point that out. You're still impartial as the private linguistic expert, but you're also hired by the defense team to provide consultation, to provide services, to provide your knowledge, right? It doesn't mean you make stuff up and you try to help them win. No, but you do provide a wider array of services based on your knowledge, experience, education. I actually was performing in this capacity just last night. So I was hired for a federal case to meet with an attorney outside of court and to prepare the case with his client. And so this is not my normal Kentucky job. It's not a sworn proceedings interpreter job for state or federal courts. I was hired by the attorney to do this. And so I did. I worked with that attorney very closely so that he could communicate with his client. In the course of those interactions, maybe there were times I was able to step out of the conduit role and provide other insights. Doesn't mean I'm impartial, but I can provide some insights. I can provide some cultural data. I actually love that work. It's one of my favorite type of things to do because you get to see the behind the scenes stuff and you really do get to provide, some insight and some input in the process, right? Different role. Wouldn't be appropriate now, at least not without disclosure, for me to interpret that same case in front of the judge as the sworn proceedings interpreter. I can't really break role, right? I can't switch over, especially when I started with the attorney. Sometimes when you start as the sworn proceedings interpreter, I'm sort of okay with you making the leap once out to assist the attorney, but I don't want you to come back. After that, on that case, I want you to be done and just assist the attorney. What I really want to avoid in Kentucky are people bouncing back and forth. Sometimes because of the language that you speak, right? Maybe you speak a hard to find language. That's the case for many of you, right? And there's just no other interpreters there. Okay, we can work around that, but there must be disclosure, right? You go to court, the attorneys see you in court, you did a good job, and you're the court interpreter, and they say, hey, can I get your contact information? Because I'm going to have to meet with this guy outside of court. Can you do it? Potentially. What I want you to do is disclose. I want you to get in touch with me. Let's talk about it. I'm Marta. Let's talk about it. Okay. I want the judge to know. I want the attorney to mention to the judge that there's no other interpreters. I would like to use the AOC interpreters. I know that this could be a potential conflict, and that's why I'm disclosing, Your Honor. Is this okay? And I want all parties to agree about it. In that case, could you do it? Yeah, you could do it. I'm okay with you doing it if there's disclosure and if there's really not another interpreter. Now, if there is another interpreter of that language, I would prefer somebody else just to do it. There's enough work to go around. So keep that in mind. I really want you to play one role in each case that you do. Actually, absolutely, Minu, it's important. Transparency, that's what we're talking about here. I want you to really work with the highest level of personal integrity possible when you're in Kentucky's courts. That's super important. I think it's so important. I want you to go above and beyond, even things that we're not even talking about, and I might even say, maybe that's not necessary. I want you to be the shining example of what that sworn proceedings interpreter or that private linguistic interpreter should be. I want you to separate the two worlds and really help us maintain that fidelity and respect the integrity of the judicial process. That's really what I want to get across in this entire presentation. That's really my charge to you. What I want you to do is to go above and beyond to represent the courts, to represent our office as you're out and about plying your trade, essentially. All right. And one way we do that is by not breaking role. So keep that in mind. That's very, very important, I think. So a few more points on this one. You're not under oath. You're not an officer of the court at that moment. You do provide constitutional access to counsel. So you are included in that privileged communication because you were hired by that person. You were invited in. Absolutely. There's an expectation of privacy. You should be there for sure. You can interpret privileged and or private communication, and you monitor the sworn proceedings interpreter. This training right now is not about how to be a sworn private linguistic expert. One day I'm going to give that training, okay? Because we need it. Because it's cool. It's cool in Kentucky because we have this whole thing where people do private linguistic expert work, and that's cool. I'm glad. Some people just make a living doing mostly this work now, and that's cool. That's really cool. And most people do it well. I don't want to say that they don't. But I have been in court as an observer and as a sworn proceedings interpreter, and I've watched how private linguistic experts sometimes work. And training is needed sometimes, right? That person has to interact with the attorney, right? If there's an objection, that's incorrect. What he said was wrong, right? I've seen interpreters stand up. Objection, Your Honor. What was said was this, and what should have been said was this. No, you're an interpreter. You can't object to anything. Don't object. What you do is tell the attorney, and the attorney decides whether an objection would be warranted or not. And maybe there's good reason for the attorney not to object. It's within the attorney's authority to decide on these things. Maybe the mistake was in favor of the defendant, right? And maybe the attorney's like, no, let's let that one roll. All right. You, as the private linguistic expert, have no responsibility to tell the court of the objection. You work for the attorney, but you do have to, or of the error rather, but you do have to tell the attorney about the error so that that person can make an informed decision about what to do. Of course, if the attorney does not object, then the attorney loses the possibility of appeal later because they didn't safeguard the objection, the possible error for the record at that time. They didn't put it on the record. They can't appeal later. They didn't object at that time. So that's really why you're there. More training is needed in this area. This is a new area, right? I think private linguistic experts have to learn how to really interact with attorneys. And so we're going to do that training one of these days. Maybe that's next year's 2-hour free online ethics training, okay? Maybe we do that one then. All right, let's move forward. So the actual definition, let's see, interpreter or other language professional hired by a non-court of justice entity. And when I say that, I mean somebody who doesn't work directly for the court, right? Court of Kentucky. That person facilitates private and or privileged communication between a party with limited English proficiency or a party who is deaf or hard of hearing and the non-court of justice entity, probably an attorney, right? The role may include monitoring the accuracy of the proceedings interpreter. All right, we talked about this kind of stuff. All right, group exercise 4. Let's do this. An individual for whom you have been interpreting is very grateful for your assistance in court. At the end of the proceeding, he or she offers you a generous tip to thank you for your service. And I'm not talking like $5. This dude wants to give you $50 for what you did. I mean, that is a nice lunch with my wife. Maybe I can even get my kids something to eat for that. I mean, that's pretty decent. Let me see what you guys say. Yes or no? Do you take it? No. Melanie says no. Let's see here. Decline. I like that. Thank you, Adriana, for being so diplomatic. Decline. I decline your tip, right? Of course not. Yeah, so we don't do that. We don't do any variation of that. You can't take it. One time I was offered, was it $10? Maybe more than that. The guy's like, hey, here it is, $10. No, you can't do that. Don't take the $10. Let him have it. I want you to be a shining example of ethical goodness, right? And you can't do it, right? Tempting, but no. Gilles at least is honest. He's like, it's tempting. How much is it? $10? No, but if you make it 50, I'll take that from you. Don't do that. Okay, obviously not. We can't do it. You guys know you can't do it. You can't take anything either. Let's say it's not money. Let's say it's something, right? Be like, hey, I have this nice um, you know, homemade thing. Here's a cake. Here's this nice homemade cake that my wife took it. And I'm looking at the cake and I'm like, that looks good. Cake is my favorite thing, by the way, guys. So I'm like, man, maybe I could take the cake. You can't take the cake. Don't take the cake. Okay, don't do it. So we know that. All right, let's move forward a little bit. Here are some possible conflicts of interest to avoid. All right, defendant is your friend, or maybe not even a friend, but you know them outside of court on a personal level. This has happened to me a couple of times. I've had to actually remove myself. They call you in court, you go in, you see them, you're like, oh, can't interpret for that guy. Hey, I'll see you tomorrow night, buddy. Right? No, you can't do that. Okay. You have an interest in the outcome of the proceeding. I don't know why you would have an interest, but you shouldn't have. You shouldn't care what happens. You shouldn't take a side. All you want is for justice to be served. Okay. Now, Nithya, that's a good point, though. If they offer you $1 million, you'll consider it. If they offer you $1 million, I want you to retire after you take it. Okay. I don't want you to interpret anymore, but take it and run. And that's it. Okay. I give you permission. If it's $1 million, you have my blessing to take it. And I want you to call me and give me 10%. Okay. And then we're both going someplace, but only in that case. All right. We're good. So, how about you've interpreted for the defense or for the prosecution in their preparation for the case? We talked about that one. Don't do it. A lot of you are doing that. Don't do it. Can't do it. All right. Not in Kentucky. Don't do it. Defendant gives you a gift, politely reject it. You can't take it. There's an example. You're out of your office, you come back, and somebody has dropped off for you a nice wheel of Mexican cheese. They gave it to the clerk or something who put it on your desk. And it just has a little note that says, thank you for your service. Enjoy. That's all it says, right? You know that it's from a defendant. You have no idea who it's from, and it's on your desk. You got it. What do you do with it? Can you eat it? Can you eat the cheese or not? Do you eat it? Let's see. Hank says put it in the comment area. I mean, who eats the cheese? Do you eat the cheese or not? Yes or no? Who eats the cheese? So you guys are thinking, you're like, man, I really like cheese. Rick, at least you're honest, Rick. You're like, yes, I will eat the cheese. Don't eat the cheese. Okay, no. Here's what you can do with the cheese in this case, because we can't give it back, right? Somebody once told me, I asked the judge, like, Judge, what should we do? And the judge actually told me, he's like, well, give it to me. I'll eat it. Like the judge would eat the cheese. Okay, here's what you can do with the cheese. You can give it away. You can break it up. There's no way to get rid of it. Break it up, pass it out to all the interpreters and the court staff. Okay, you can do that. Yeah, I think we're on the right track here. Okay. Do not just take the cheese, the big wheel of Mexican cheese home, share it with your family. Don't do that. You shouldn't do that. Okay. So we're on the same page with that. Let's see here. You hate the attorney so much, or he makes you so mad that you can't interpret impartially. I don't know what this dude did to you, but don't interpret, okay, for that guy. That's going to lead to bad things. I don't know what you got against this person. Let it go, but don't interpret. The defendant is accused of a crime of which you were once a victim. Maybe. This isn't an always for me. It's not that you would always have to do this, but maybe, especially if it affects you on such a deep emotional level that you can't be impartial. Maybe, right? You shouldn't take that case. Absolutely. For example, the defendant is facing the death penalty, and you are very much against the death penalty, and not even that you're very much against it, but you're so much against it that you can't maintain your impartiality. You may, in your personal life, be very for or against something, a crime, a death penalty, whatever it is. Doesn't mean you can't interpret, but if it affects your ability to maintain your impartiality, you shouldn't be interpreting. I've really never found anything as I've gone out in the field to interpret really to the level that I couldn't interpret. The closest thing to that for me, the thing that bothers me the most, and the thing that I do try to avoid, although I'll interpret it, it's fine. But the thing that I avoid if I can, I don't like interpreting, things that deal with child abuse, child molestation. Um, that's just not something that I like to do. I can do it. I do it. It doesn't affect me to the level that I couldn't interpret, but I don't like to interpret. I can feel myself. I have to remind myself in those cases why I'm there, and I have to focus on the linguistics because I can feel myself getting very angry sometimes. I'm actually sitting there close to the guy, and I'm literally thinking in my mind, I could kill you right now. I could actually kill. I could attack you right now. Nobody could stop me, right? And I think about that. I can feel myself getting red, feel my face getting red, right? I'm able to control that, and I'm able to interpret in that setting because I know that what I do is important. I know that justice has to be served, and I know that I'm a part of that, and I want that to happen. So I can control that, but that's the closest thing that I have to that. I would prefer not to interpret that if I don't have to. If there's nobody else, I'll do it, but I try to stop. So think about your personal experiences. If I called you up and said, could you interpret this type of case? And if you said, I would prefer not to, I just don't like those kind of cases. Would that affect your ability to work with the AOC going forward? Would it affect, maybe the way that we think about you and maybe we wouldn't call you back? Absolutely not. Absolutely not. In fact, I thank you for doing that up front so that we don't have a problem when you get there and I have to pull you out. That would affect you, right? Because you really should have told me up front. But if you deny a case because it's one of these sensitive issues, totally fine. No questions asked, really. Just tell me, you have some concerns and you're just not comfortable for whatever reason. Good enough. And I don't want you there doing something you're not comfortable with that could affect the proceeding. Okay, so keep that in mind. Know yourself, know your limitations. That's fine. All right, let's move forward here. Scope of practice. Interpreters shall limit themselves to interpreting or translating. They shall not give legal advice or give counsel or express personal opinions to individuals for whom they are interpreting. Interpreters shall not engage in any other activity that may be construed to constitute a service other than interpreting or translating while serving as an interpreter or translator. So you got one job, and it's a hard job, okay? Really hard job. You have enough on your plate to think about when you're there already, and language is flying in and you're spitting it out and you're trying to keep up and you've got all these ethical parameters and you're playing this very defined role in this big game of judicial chess, right? You've already working through all that kind of stuff. You don't need to do somebody else's job. If there's somebody else, my rule of thumb, if there's somebody else who is paid to do what it is they're asking you to do, you should decline and that person should do their own job. An example. Um, yeah, Mr. Interpreter, would you mind? I know you're on your way down to the first floor. Would you mind taking this file folder down to Billy Bob? He's in courtroom 101. Give it to him and you tell him Charlene said hello. All right? Can you do it? No, you shouldn't do that. Because what if on the way down there you're called and another courtroom needed you and you didn't make it there and now this folder is out floating somewhere and they didn't even have it, right? There's a lot of responsibility. That person is paid to do that. Let them do that. Now, if you're in the courtroom and they say, now Sugar Plum, you see that man right over there, can you just hand this folder to him? Thank you so much, darling. Can you do it? Yes. Okay, you're human. Yes, ma'am. Okay, I don't mind being helpful. Being helpful is different than doing someone's job. Be human, okay, but don't do somebody else's job. Let's see here. Things that you must avoid in the role of the sworn proceedings interpreter. I'm talking about when we hire you and you are sent to court to interpret in court, impartially on the record. You can't give cultural expertise. Even when you know everybody's got it wrong and you could clarify it and you're just astounded that they don't know this. You can't do it. That's not your role. That's not why you're there. Clarifications. You cannot clarify something for others' comprehension. You can clarify for your own comprehension. If somebody says something that you don't know, you can clarify. Your Honor, may the interpreter clarify? Your Honor, an ambiguous term has been used. May the interpreter clarify an ambiguous term? Sure, go ahead. Ma'am, what did you mean when you said this? You can clarify that way, but you cannot clarify something that was confusing that the defendant said or that the judge said. You know that there's some confusion there. You can't clarify that. That's not your role. You just keep going. You don't do that at all. Even if somebody says, like Shivani, Sugar Plum, they say, Sugar Plum, clarify what you mean. You can't clarify that. You're just Sugar Plum. You just say it and you just move right on with your life, all right? You cannot give legal advice. Warning, bad lawyer ahead. Don't do it. You are not an attorney, even if you are an attorney, and some of you are. When you're working for us, you're not an attorney. You are a sworn proceedings interpreter. You have to take the attorney hat off. That's very hard, right? And it's strange because I'm not an attorney, but I've done this so long that sometimes, like my attorney hat, I want to put it on because I want to tell these attorneys, like, look, I've done this a lot longer than you've been here. I can do this. Give me 5 minutes. I'm gonna straighten this out. I want to say that sometimes. The guy's trying to explain the the rights to somebody. Sometimes I just want to say, look, you're sort of making a mess of this. Let me handle it. I got you. I got you. Hold on. And just do my thing. I can't do that. I'm not an attorney. Don't do that. Take it off. Take the hat off. Advocating, you cannot advocate. You cannot, on any level, be an advocate for anything in court. You may be the biggest proponent for immigrants' rights, for language access. You may hate the way that people are being treated in court, and all of that means absolutely nothing when you are our sworn proceedings interpreter, because that is not your role. You may do that outside of court. That may be something very valuable, something very worthwhile to pursue. But when you step into court, you have no political affiliation, you have no specific interest, you are not an advocate, you're there for one reason and one reason only. Keep that in mind. That's important. You're not there to explain anything, you're not there to do clerical work, right? Let's do another group exercise. Number 5, the victim in a case of assault, domestic violence, for whom you interpreted a few weeks ago, sees you walking in the hall between courtrooms. She tells you that she wants to file for divorce and that she has the forms with her. She asks you if you can help her fill out the forms. So, you're the interpreter, you're in court, you're walking through the courthouse, right, in the hall, and somebody sort of catches you and they're like, hey, I want to fill out, I want to request a divorce, and can you help me with the forms? Can you help? Let's see what you guys think. Yes or no? I want to make sure everybody's on mute here. Hold on, guys. I'm going to mute you if you're not. I'm looking through to make sure. So most people say no, can't do it. Run, run, run away, fast and away. Okay, interesting. This is an interesting situation, right? So I'm sort of going to put on my administrator hat right now and talk to you about federal guidelines and what we have to provide. So we do have to provide language access for this woman. She's coming to the court to look for a service, um, to request a service, right? She wants to file a divorce petition. That is an official court form, and she has to do that probably at the clerk's office of whatever court, the family court, clerk's office, whatever it is. So when she makes her way there, we have to provide language access. Now, it doesn't necessarily have to be you as the interpreter, but is there a problem with you doing it? There's really not any problem with you providing that language access. I don't have an issue. I know some of you are surprised. You're like, wow, really? Like, yeah, this is okay. What you can't do is give her advice on whether she should fill the form out or not. You can't fill the form out for her. Okay, you can't do that. But can you provide the language access to her to fill out the form? Potentially. We do have a responsibility to provide language access, and that could consist of an interpreter assisting in sight translating the form for her to fill it out. Could be. What needs to happen with her, she should be directed to the appropriate clerk's office. Probably at that office, they have the form in Spanish. We have lots of forms in Spanish there, right? She should fill out that form in Spanish. The clerk would then take that form, and they use language line, they use other things to do that. But could you, as a sworn proceedings interpreter, do this type of thing? Yes. Now, we actually have something in our administrative procedures that says we can interpret in court proceedings, or we can interpret for things that are called direct services. Okay, so that's really the bottom line with what we can provide in court proceedings, or things that are not court proceedings but that are considered direct services offered by some department under the umbrella of the Court of Justice, right? A direct service could be, for example, the clerk's office accepting the petition for divorce, right? That's a service that we provide. An English speaker would be able to go up, ask for that form, fill out the form, and put it back, right? And submit it back. So there has to be some language access there. We can't fill out the form for her. There could be some assistance in language access. The best assistance we should provide would be giving her a translation of the document, which we have, right? That's fine. Could you facilitate the communication, let's say, between that person and the clerk at the clerk's window? Yes, you could. That is a fine interaction to facilitate, because again, it's a direct service. That clerk works directly for the Court of Justice. So could you interpret that? Yes, you absolutely could. Now, could the clerk use language line? Yes, they could use language line as well. And some of you have said that as well. That's an option. But do I have an issue per se with a sworn proceedings interpreter interpreting an interaction between, say, a clerk and an individual who is LEP at the clerk's window? I'd be okay with that if you're available. Pragmatically, it doesn't happen a lot. You're not available, you're in court. But could that happen? I'd be okay with that. If somebody came up in the hallway and asked me this, frankly, I would try to avoid the interaction, but assuming that I understood what it was about and they asked me this, I'm going to be human. I'm going to direct her to the right place. And I'm going to tell her that they'll be able to assist her, that they'll have language access available, either in the form of language line or translations, and they can assist. If they call me when she gets there, right, and they say, can you come interpret? I could interpret. I can interpret that interaction. I'm not going to help her fill the form out, but I can interpret. So just an FYI. Now, Adriana says, what if the person is illiterate? Well, we can't fill the form out for them, right? Being illiterate is different than not speaking English or having limited English proficiency. So in that case, we would do what we would normally do for an English speaker. We would give them the form. We have the form in Spanish, and we could get the form in whatever language they needed. We could give it to them. They would have to take it, and it would be on their own to understand the form and to fill it out. They'd have to have somebody assist them. We wouldn't help them fill out the form, especially if we have the form in Spanish or another foreign language. And we do. We have those forms, or we can get those forms in any language needed, right? So there's a difference between facilitating the language access and just doing the work for the person. We can't do that, right? So yeah, if a person were illiterate in Spanish, same thing, Nydia. I would have no problem giving them the form to fill out. They fill out the form, bring it back. They have the form in Spanish, filled out in Spanish. Then we can certainly facilitate the language access to get the content of that form onto the English form. That would be okay. Just have to be careful there. So there's a fine line. But in the end, do we provide some language access there? Yeah, I'm okay with it. All right, let's go forward, guys. We're cooking now. Things that you cannot do, things that you are not. Okay, sort of going back to maintaining your role. You're not an attorney. You're not an advocate. You're not a buddy or a confidant. I don't want to see you out there buddy in the hallway with any of these defendants. You're not an investigator. Don't go looking for the answers. You're not a gopher. Don't do anybody else's work for them. You're not a parental figure. People are going to come to you and they're crying all the time, but that's not your role. Be human, but get out of the situation quickly. You're not a cop or a judge, definitely not a judge, not a secretary, a psychologist, a problem solver, a cultural broker. You're not any of those things. You have a really hard job. You are an interpreter and or translator, perhaps. Stick to the linguistics, stick to the language side, and you'll be okay. You really want to be careful here because all of these things, right, we could sort of venture into any of these roles depending upon our interactions. You want to be very, very careful as you're moving forward. Stick to interpreting, stick to translating, go out of your way to avoid interactions. Try to avoid the perception of a conflict, and you'll be okay. Err on the side of caution, all right, if in doubt. Group exercise 6, let's do this. You are in the middle of the pretrial docket in courtroom number 6. During a break, one of the defendants for whom you've interpreted and whose case is still pending comes to you and asks, what do you think I should do? Should I plead guilty or should I get a lawyer? Right? You tried to avoid the situation, but he caught you, and it happens sometimes. What do you do? Can you tell him? Can you give him yes or no? Can you give him a list of attorneys that speak his language or not? Let's see what you say. People say no. Most people say no here. Let's see. Okay, I'm seeing a few more pop up. See, now with that last one, I sort of tricked you, right? And you're thinking, man, I don't know. Can I do it now? You're like, maybe not. Okay, good. At least you're, Cecilia, at least you're honest. I don't know, right? Right. Okay, so let's talk about this one. This is typically something I would avoid. I would recommend that we avoid this in Kentucky. When people call my office, they call my office and they ask for interpreters. Okay, just to give you an example. I need an interpreter of this language. I don't mind referring them to the list that we have. You guys know that we have a list that we share publicly. I can give them all the interpreters on that list that are contracted with us. I don't mind doing that, right? If you were going to do something like this, you would have to do something similar. You'd have to have every person, every attorney who speaks the language, who can handle this type of case, and it's just unrealistic. You don't have that knowledge. You couldn't help but favor one of these attorneys, even if you gave them 3 or 4. There's still other attorneys out there, right? So I want you to be very careful. I don't want it to seem like you, as a representative of the Office of Language Access, while you're working as a sworn proceedings interpreter, is providing some type of advice, some type of guidance, some type of direction to someone looking for an attorney. I know a few attorneys that I would probably recommend on a personal level, right? I mean, there are some good ones that speak the language I speak. I understand that. I want to try to avoid this. In this case, what would we say? I want you to really get comfortable with this. Ma'am, sir, I'm an interpreter. I can't assist you. I'm sorry. And I want you to just walk away, right? Even that basic communication you just had. Could there be the perception of a conflict if somebody sees you talking? Yeah, it was very innocent, but I want you to limit that interaction. I'm totally fine with you saying, I can't help you, I'm sorry, and walk away. Be human, be nice, but walk away. Whenever I was first starting this, I was much less comfortable just saying no. You don't want to be rude to people. So I'd come up with inventive ways. They would start talking to me and I'd look at them and all of a sudden, my cell phone, I would pretend like it was ringing. I'd pull it out. I got a call, hold on. And I would just walk away quickly, right? And sort of lose myself somewhere in the hallway. You could do that, or you could just say no. Just, ma'am, I'm sorry, I can't assist you. I apologize, and just walk away. You may even say to them, I'm not allowed to speak with you. I'm sorry, and walk away. It's okay. People will say to me, well, culturally in my language, that would be so rude. It would be horrible for me to do that. This is the expectation as a sworn proceedings interpreter, and I need you to follow it. Be diplomatic, be human, um, be kind. You can be kind, but also reject their request. I can't assist you. It's not that I don't want to. I just can't. I'm prohibited. Please forgive me. And then walk away. It's okay. It's okay to walk away. It's okay to say no. All right. Yeah. And Akiko, just like you said, explain that the interpreter can't provide advice. I'm here as an official interpreter. I'm not allowed to provide advice. Forgive me. Bye. Right. Walk away. I want you to do that. We just simply can't do it. Let's talk a little bit about confidentiality and maintaining confidentiality. Attorney-client privilege may apply to the role of the interpreter depending upon the role that person is playing. We talked about this. If you are a sworn proceedings interpreter, you're not really included in that attorney-client privilege, not really. If you're the private linguistic expert hired by an attorney, that would be a different situation. But what I want you to understand is there's a difference between privilege and confidentiality. And people really get confused between these two concepts. And I want to explain just a little bit about them so you understand the difference. Privilege is something that attorneys have a whole class on, or maybe a couple of classes on in law school, and they still have difficulty sometimes understanding the nuances of privilege. And we don't have to have that deep of a grasp of privilege to really have a working knowledge of what we need to do, right? So we're not really trying to define everything that's privileged or confidential, but here's what we need to know. Confidentiality, maintaining something confidential, that's the requirement that you guys have in our code of ethics. And that is a rule that applies to you. You and you alone can decide to break confidentiality or not. Somebody tells you something, the sky's blue. You decide to maintain it confidential. You decide, in fact, you don't decide, you have a rule that says you must maintain that confidential. There's nothing secret per se about that information. The sky is blue. Well, everybody knows the sky is blue, but you are not allowed to talk about the sky being blue. You maintain it. It's a secret that you have, that you carry the burden of, that you cannot break, right? Confidentiality resides with the interpreter, with the worker. If something is confidential, it means that ultimately you are charged with keeping that secret, okay? If you tell it, then you've decided to not maintain confidentiality. You reveal, you disclose something, it's no longer confidential, right? You tell somebody else. That decision is on you. Privilege is something that only resides with the client. It only resides with a criminal defendant, with the client, between the client and attorney. That privilege, even the relationship between the attorney and the client, that privilege resides only with that client. Only that client can give authorization for privilege to be broken or to waive privilege, right? So let's say that you are included in privilege. You're the interpreter or you're the attorney. You're included in privilege. And let's say as the interpreter, I turn around and I was the private linguistic expert and I found something out in privileged communication, right? The privilege is with the defendant. The defendant did not give me permission to reveal. But let's say I turned around and I revealed it. Let's say that I told the prosecutor what was said. I was part of that privilege. Let's say that I really was. I was part of the privilege. And I turn around and I tell the prosecutor what was said. And so he knows now what was said. He knows it. But I wasn't given permission to disclose. Nobody waived privilege. That privilege can only be waived by that defendant. And so even though the prosecutor technically knows it, it's as though that person doesn't know it because he received it through illegal means, inappropriate means, right? If he went to court and tried to introduce it, the attorney would say, well, where did you get this? Well, I got it from the interpreter. What? The interpreter was part of privilege. My client never waived privilege. We couldn't let you have it, right? You couldn't use that even if you got it. So privilege always resides with the client, with the person, with the defendant, with the LEP. Even the attorney can't decide to waive privilege. Only the client can. Confidentiality resides with you. What I'm telling you is in Kentucky, according to our code of ethics, you must maintain things confidential. In fact, I want you to maintain everything confidential, even if it's not privileged or if it's not confidential. Just treat it as though it's confidential. Don't share it really with anyone. You can talk about general anecdotes with fellow interpreters. This is what happened. What would you have done? But all of the case information and names, I want you to maintain all of it confidential. That's a requirement and a rule that applies to you as the interpreter. That's your responsibility. That's your obligation. Privilege is a different thing, and you as a sworn proceedings interpreter are not included in that privilege. And only the defendant, only the client can actually agree to waive privilege, really. So keep that in mind. I want you to think about that. That's the difference that I want you to know. So our obligation ethically is to maintain confidentiality, right? Now, you may or may not be included in privilege depending upon what the judge says, or I'm sorry, depending upon what role you're playing. Having said that, if you're the private linguistic expert, there's probably privilege expectations. If you're the sworn proceedings interpreter, you shouldn't be in those conversations at all anyway, right? There's just no privilege that extends to the interpreter in this case. Now, there are things that are squarely confidential, right? So we talk about, of course, attorney-client privilege may apply if you're in that role of the linguistic interpreter, right? Private linguistic expert. On the other side, there's interviews with victims. So we're talking about a prosecutor doing an interview with the victim, and there's an interpreter there, right? You would be part of that privilege, assuming that you are hired by that side. There's interview with witnesses, same way. There are closed or sealed hearings. They're confidential hearings. You have a responsibility to maintain those confidential. Those include things like juvenile court. Anything in juvenile court is confidential. You may not talk about it. You must not share the information. If you take notes, I want you to destroy your notes when you're finished. I want you to throw them away. My notes, I couldn't read them anyway after a few days, but go ahead and shred them, throw them away, rip them up before you even leave the courtroom. It's a good idea to do that. If you're at home doing it remotely, rip them up, throw them away, make sure nobody has access to them. An odd thing that has come up recently that I do want to mention, if you're providing remote services in a confidential proceeding, like a juvenile proceeding, make sure there's nobody around, right? Your kid may walk through the room. You've broken confidentiality. You're interpreting in your car and somebody's sitting in the other seat. You're not maintaining confidentiality. Make sure you take that into consideration. One time I was interpreting for a jail visit with an attorney as a federal case, and I was interpreting. Um, I was hired by the attorney, so there was privilege, and I was in my home office, and unbeknownst to me, I don't know what I've got 4 kids. One of them came by in the background. And, the defendant, I can see the defendant in jail in front of me, and my kid like walks in the background, right? And the attorney stops. He's like, "Mr. Elliott, I believe you have a visitor." And I turn around, and there he is. He's hiding back there somewhere. I'm like, "Get out of here!" Right? Careful, we're breaking confidentiality. Make sure that you ensure that you are in a situation to maintain confidentiality. Grand jury proceedings are always confidential. I love interpreting in grand jury proceedings. They're really cool. Always confidential. Nobody else can go in. Maintain confidentiality. Any material, evidentiary material you come in contact with, it should be treated as confidential. If you are preparing a transcript translation for an attorney as the private linguistic expert, then there's privilege attached to that document as well. Keep that in mind. That is your work product. You're giving a private professional expert opinion on that. You may be called to testify, and there are ways for that to happen. That would be fine, but otherwise you should maintain confidentiality. Make sure that you understand these things. For the purpose of our ethics, as a sworn proceedings interpreter, the obligation is for you to treat as confidential, all sensitive information. And I would just say in general, anything you do in court, just treat it as confidential, even if it's really not necessarily confidential. Things will go better for you in life. So here we have the canon: interpreters shall protect the confidentiality of all privileged and other confidential information obtained during the course of their official work, right? And in your official work, you shouldn't be in those privileged communications. Remember that. Treat everything as confidential, and you'll be fine. You'll be good to go. Let's take a look over here. I got a couple of questions that have come up recently. Let me go back. Let's see here. Give me a second. Sort of going back through here. So Abdi says you're here to facilitate communication, not give advice. That's excellent, Abdi. Thank you for that. Let's see here. Sixta says, how about when someone asks you for a list of other interpreters for rare languages? Should you provide it or not? Sixta, I would not. I just wouldn't. I think I think that it could be viewed as a conflict, as a bias in favor of those interpreters. You're sort of trying to direct them to specific interpreters. What I would do in that case, and this is for all of the interpreters out there, if somebody asks you, do you know anybody who can assist? Do you know anybody of these languages? And if you're there as a sworn proceedings interpreter for us, just direct them to my office. Direct them to call the Office of Language Access. Tell them, hey, the Office of Language Access has a whole list of languages. They can help you find somebody. Let's just leave it at that. That's probably the best way to go. And then I'll assist. I can give them the names of anybody we have on contract. There are other resources I can give them. If you're, you know, out about and on a personal level, if somebody asks you, yeah, you can make recommendations all you want. But if you're working for us in the course of your official duty, I would just avoid that. I just wouldn't do it. It could just lead to questions. Let's see here. When the defendant is speaking with their attorney at the podium and the judge says, interpret, Rosemarie, let's see, when the defendant is speaking with their attorney at the podium and the judge says interpret, okay, I see. So you're at the podium, the defendant turns and speaks to them, right? Speaks to the attorney. Is there privilege there? Should you interpret it or not? For me, it would depend a little bit. If it was something that's audible so that I can hear it and that any native English speaker would hear it, if the judge can hear it in their language, he just doesn't know what they're saying, generally speaking, I would interpret. Remember what I said about there being no expectation of privacy. If you're talking about private stuff in the middle of the courtroom out loud and everybody can hear it, there's no expectation of privacy and I have to interpret. I'd be fine. Now, if they step away and they quietly whisper back and forth, I'm not privy to those conversations. I shouldn't be anyway. I would not interpret that. If the judge asked me to interpret, I might say something like, Your Honor, the interpreter cannot hear. The interpreter is unable to hear what's being said, right? I might solve it that way, but I typically wouldn't interpret. But if they just sort of talk, they'll say something like, should I answer? Should I interpret? But I told you that was not what I said. If it's audible, if I can hear it, if an English speaker would have heard it standing there, I would interpret it. That's my obligation. So keep that in mind. What about, let's see, going through here. Hold on. Joshua, isn't the list on the court database public domain? Yes, it is, Shivani. Yes. We're updating our website, by the way. Soon our website will include a much better searchable database of all the interpreters we're contracted with, unless you told me that you don't want to be on there, of course. That's coming in the next, I hope, month or 2 months. They're working on that. But yes, it's on there. You can direct them to there as well. They can call our office or they can view that. The most up-to-date information will be calling our office, but then we'll get that list updated, very frequently as well. Cool. Let's keep going. All right, we're rocking. We're cooking with gas. We're right on track here. Hang with me, guys. We probably will go to right at 3:30. We'll finish up maybe a few minutes early. Group exercise 7. The court interpreter is approached by a newspaper reporter to discuss a case. The reporter simply wants to ask a few questions, and the proceeding that the interpreter just interpreted wasn't confidential. It was public domain. Is it okay for the interpreter to speak with the reporter? Case is done. You're finished interpreting. Can you do it? Let's see what you guys say. Not at all. Can't do it. No way. Yeah, true story, guys. Okay. True story. You know, this type of scenario, I give this in our orientations. Every interpreter that interprets for us, certainly here in Kentucky that goes to orientation, they hear this. This is sort of standard court interpreting stuff in most states. So I had an interpreter who had heard this, and they were in court, and it was a day that I wasn't in court. I was out of the office, and I'm there most days, right? It was when I was in Louisville. So one of our interpreters came in, and this person didn't interpret a whole lot. Sort of a rare language kind of thing, but they'd heard this. And the one day I'm not there, the press, like a local news channel, decides to do a show, a segment on how much money we're spending on language access in Kentucky. And they sent a reporter on site, and that reporter was, taking pictures and recording, and they actually got a hold of this interpreter, my interpreter, and they did an interview with the dude right out in the hallway, right? And they're like, hey, would you mind giving me a couple of sound bites? Let me ask you, how much do you make? What do you do? They did all this stuff. Should he have done it? Probably not. It wasn't about a case. They were asking him generally about like the profession of interpreting. He did it in the courthouse itself. I would prefer to avoid that kind of thing. Could you talk to the press generally or some news source generally about court interpreting? Okay, do it, do it not in the courthouse, while you're working. Okay, maybe. Should he have done it? I would have been more comfortable had he not, had he directed them to me. I did talk to that reporter at some point, right? And we gave him some official statements sort of from our office, but should he have done that? Okay. Another true story. One of the first things I ever interpreted as a court interpreter. I'm sitting there in my office. Like the first week or two, I was on the job, and didn't know much about anything. I was just ready to go, certified, ready to go. And they called me from circuit court, and they're like, "Hey, can you come up and interpret? We just have the sentencing that we need to interpret, and we forgot to ask for an interpreter." Yeah, I'll be right up. And I walk in. There's press everywhere, cameras everywhere, news channels everywhere. The defendant sitting there looking at me like, "What did you do?" Right? I sat down, put the equipment on. I got my little microphone. All right, I hereby sentence you to life without the possibility of parole for the murder of your fiance. Apparently this guy had bashed his girlfriend in the head with a hammer, killed her. It was all caught on tape. Um, it was horrible. I'm thinking, what did you do? The press was all over the place. I actually was on the news that afternoon. You see me in the background, right? I sort of look like a deer in the headlights. I'm like, what did you do? I'm thinking, Michael, what did I get myself into? Right? I didn't comment. I didn't talk to them. Would they like to have talked to me about it? Absolutely. How was it to be so close to this murderous fiend? Certainly would have liked a soundbite. Don't do it. You can't do it. Representation of qualifications. Interpreters shall accurately and completely represent their certifications, training, and pertinent experience. Are you certified? Yes, I am. CPR. No, that's not what they mean. Are you certified? Yes, I am. I'm a certified public accountant, and I'm here to interpret today. What? No. Are you certified? You are a court interpreter, and you know what they want. And interpreters sort of dance around this question, like, I have been trained. I'm a qualified interpreter. I've been trained in this and this and this. I've attended this specific course. I have been trained by the famous so-and-so person. But you know what they want. They want to know about your certification level. Your Honor, I'm not certified. There's actually no certification for the language I speak, but I am professionally trained and I have been qualified by the Kentucky Office of Language Access. Fantastic. Are you certified? Yes, Your Honor, I am certified. I'm state certified. Okay. Represent your qualifications. Don't try to inflate your qualifications. Bad things happen if perhaps you're not qualified to do that job, or maybe you are qualified and the judge just decides they want something different. It's okay. You live to fight another day. You know what they're asking here, all right? And answering the question, make sure you understand the context. They want to know about your credentials. It almost never happens where they do this. Judges don't often ask this, but one time I had to go to Indiana. It was Indiana State Court. I used to interpret in state court there a little bit as a freelancer, and I went in, and this judge was just, very thorough. And she asked me, "Mr. Elliott, thank you for coming today. Are you qualified to interpret in court?" "Yes, Your Honor. Yes, I am." "Can you tell me your qualifications?" And this was great because I'd been waiting years for that question. I had it in my mind what I wanted to say, so I was like, this is my moment. Your Honor, thank you. Thank you for the opportunity to interpret for this honorable court. I just laid it on her. I mean, I gave her everything. I gave her every piece of education I had, every certification I had, and I was ready to go. I kept talking about trainings and everything. I was just going to give her the whole spiel. And at some point, 2 or 3 minutes into it, "Hey, Mr. Elliott, thank you. Thank you for being in our honorable court today. You honor us with your presence. Please interpret for you." It was fantastic. It was the best thing I ever got to do in my life. Right at the end of it, the judge like, "Please come back." I don't think she was expecting that, but I had it prepared. It was off. So you might prepare something like this. Have something that you sort of have in mind. What you need to hit are your education, your experience with the language, your experience as a court interpreter, your certification level. So these kinds of things, have these off the tip of your tongue, ready to spit out if asked, right? Let's see here. Assessing and reporting impediments to performance. Interpreters shall assess at all times their ability to deliver their services. When interpreters have any reservation about their ability to satisfy an assignment competently, they shall immediately convey that reservation to the appropriate judicial authority. So I'm going to send you guys, along with the recording and these slides, I'm going to send you some uh, some articles that I found over the years about interpreters who have done unethical things along the way. And one of them is about a French interpreter who was interpreting for a guy named Floyd Landis. Some of you may know who Floyd Landis is. He won the Tour de France, bicycling. He won it several years ago, and then he was caught for doping, and that sort of opened the door for Lance Armstrong and all of those guys to be caught for doping. And so he was caught for doping, this Floyd Landis, and he went to trial. And the doctors and scientists that had, I guess, analyzed his urine samples and his blood samples, they were from France because it was the Tour de France. And so they flew the doctors over and they had to testify in French. And they got an interpreter, and the interpreter did not do this. The interpreter, I think the interpreter thought, man, this is a big case and I'm a good interpreter. I think he was certified, um, and he just didn't do this. It required some very specific technical knowledge and some research. This interpreter probably could have interpreted correctly had he put in the right time, but he didn't do this. And he got on the stand and it was horrible. They actually had to fire him in mid-morning. They called up another interpreter, sort of got her in. This other interpreter called her on an emergency situation. Can you come in? She came in and did exactly this. I'll do my best. I'm not prepared. I don't know anything about this case, but I'll do the best. And she did a really good job with it. That other guy, and his name actually was Pierre. I know that's like stereotypical, but his name was Pierre. And it says it in the article. That's how I know it. And Pierre is not interpreting anything anymore. Pierre is like working at a French-speaking car wash somewhere in East LA because he no longer can interpret because he lost all credibility. He didn't do this. So make sure you do this. It's okay if you're not comfortable, if you don't have the training yet to do something. It doesn't mean that you couldn't do it at some point. It just means that right now at this moment, I need an interpreter to do this. Can you do it? No, I cannot. Thank you for telling me that because you just avoided a huge headache for us later down the line. So it's okay. You're not penalized for it. A year from now, maybe you've gone through more training, you're more comfortable. It's fine. You live to fight another day. Um, Other impediments that you may have to overcome. Uh, we talked about the judge speaking quickly. That's an impediment. Your responsibility is to stop the court. We talked about attorneys. Maybe attorneys trying to get you to do something outside of your ethics. You have to overcome that impediment by telling them no, by informing the judge, right? We'll talk a little more about that in a moment. Your job, if there's an obstacle to you performing ethically and to performing appropriately and precisely and accurately, you have to overcome that somehow. You have to address the situation. It could be by calling us, could be by talking to the judge, but you got to do it. Let's do an exercise. So you're summoned to courtroom 1, where Judge McCoy, I call him the real McCoy, he's conducting arraignments. As soon as you walk in, he sees you. He knows who you are. You've been there a lot of times, right? You've been in this courtroom a little bit. And he says to you, Mr. Interpreter, we got 2 defendants for you today. I want you to go ahead and explain to them how we do things around here. You know what to do. Give him the spiel. Go out in the hallway. Take the form and go through his rights with him. Tell him how we do it, and you bring him back in here, and we'll get it done. All right? First off, can you do it or not? Nydia says no. Greta says, Your Honor, I cannot explain. She's taking the diplomatic approach. All right. So let's see here. I'll have to contact the EOC. Okay, Nara's passing the buck. She's like, look, if I do this for you, I'm gonna have to call Joshua. I'm gonna get him on the line right now. Okay, nicely declined. Thank you. We can't do that. So this is interesting. So we know we're not supposed to. We've talked about this. Many of our rules have to do with this, but how do we get out of it? We have a judge. You can't just sort of say no. So how do we do it? Let's see here. Now, Melanie says, well, we shouldn't, but if we're ordered to read the Rights Act, we must obey the judge. And that is a true statement. So let's talk about that. Let's see how this goes. And yes, there should be an explanation. Can you go out in the hall, Mr. Interpreter? Would you mind? Can you go out in the hallway and tell them how we do things around here? I want you to be strong, and I want you to be brave, and I want you to be very diplomatic and professional, but I want you to say, Your Honor, forgive the interpreter, Your Honor, actually, ethically, I am not permitted. The interpreter is not permitted to explain or to even be alone with the defendant outside of the presence of the court. There's a Supreme Court order that prohibits me from doing that. I will do whatever the court would order me to do, but I have some concerns ethically, have some ethical concerns about doing this. How would the court like to proceed? Typically, when you say that to a judge, that's going to be the end of it. They'll say, oh, I didn't even realize that was the issue. That's fine. I'll do it on the record, okay? Or they may say to you, they may say, Mr. Elliott, thank you for bringing that to my attention. I'm just busy today. I realized that this is putting you in a difficult situation. I need to get it done. I want you to go out in the hallway and do it. Can you do it? What you should understand about that when that judge says that, they've said it sort of nicely, right? You understand that it still sounds like a request. It's not a request. It's an order, okay? Know that. So you've explained your position and the judge says, I want you to get it done. Yes, Your Honor, I'll be happy to do so. When that happens, I want you to go and do it. I still want you to maintain your ethics in that situation. All you can do is sight read the document, right? That's all you can really do. You can do the task that was given. And then, okay, I want you to follow up with me, with Aymara, with our office, as soon as you can so we can address this issue. This is happening less and less. It does still happen. We've changed the culture over time, but it still happens. But I want you to follow up with us so we can address the issue. Usually when this happens, it's because judges feel they don't have any other option, right? They don't have any other resources, any other tools. And a lot of times we can offer them other tools. We can walk through different scenarios with them, right? But we need to have that conversation with them. So I want you to follow it up. Now, Greta says, can we do it when they give us the written rights? You can, Greta, but even in that case, I want you to say, Your Honor, I'm happy to sight read this to the defendant. The extent of what I can do, however, is sight read it. So you can sight read it. You cannot explain. Definitely, if they tell you to explain the rights out in the hallway and there's no document, there's nothing to sight translate, you just can't do that. You don't have that knowledge. That shouldn't be happening. There have been judges that have asked me, can you take the guilty plea form out there, read him these, and make sure he waives his rights? What? Me make sure he waives his rights? No, I can't do that. Your Honor, forgive the interpreter. All the interpreter can do is sight read. At most, the interpreter can sight translate the document to the defendant, and then the interpreter is happy to come back in and facilitate that communication. I can't have him waive his rights. I'm not an attorney, right? Understand this thing. Be diplomatic. Make sure that you adequately explain your concerns and your ethical boundaries here. Let's take a couple of questions here. Lisa says, Your Honor, I'll be happy to interpret anything needed on the record. Absolutely. That's the best way. Your Honor, ethically, I'm not allowed to be alone with the defendant. However, I'm happy to interpret anything that Your Honor might need to say on the record. Sure. That's what should happen. That's really what we'd like to happen. Nithya says, there's a difference between sight translating a document and explaining. Absolutely, there is. We can never explain, for sure. Great point there. We just sight translate. And if there is no document, there's nothing for us to do. We can't sight translate what we don't have, right? There should be an attorney. There should be somebody explaining this. We can certainly explain. We can certainly help them facilitate communication. We cannot explain directly to them. There's no document. We have no role there. Keep that in mind, right? All right, let's do it. Professional demeanor and protocol. Interpreters shall conduct themselves in a manner consistent with the dignity of the court, observing established protocol, rules and procedures of interpreting, and of the court. Interpreters shall be as unobtrusive as possible during any court proceeding. This should go without saying, but I'll mention it anyway. All courts like this in the United States, but I'm talking about Kentucky. I want you to be artificially formal when you go into court. The courtroom is an artificially formal place, and I want you to adhere very closely to those standards. I want you to dress very well. Um, when you go to court, I want you to have, if you're a man, I want you to have a suit and tie on. You tell me, well, Joshua, I don't like ties. Well, I would say to you, well, I don't care. I want you to put a tie on. I want you to have a tie. I think that you should have a tie when you go to court. It can be a bow tie. I'd be okay with that. A little bow tie is okay, but you got to have a tie. If for our female interpreters, whatever it means to you to dress as formally as you would in the most formal of occasions in your life. You go to church, you go to a funeral, you go to a wedding. What would you put on for that? For a lot of women, maybe that's a dress suit. It could be a skirt. It could be a dress, whatever you're comfortable with. But I want you to be as formal as you would in any other very formal setting. That's important. If you're providing remote services for us, okay, like you can see me now, I'm not appropriately dressed for court, right? I may have shorts on down here. I don't care what's from here down, but from here up, I'm not appropriately dressed for court. If I'm going to turn on my video and do remote interpreting, I want you to have a suit and tie. I want you to have your dress on. I want you to have whatever it is, right? Your suit, jacket, whatever you do. I want you to have that on. I want you to see. I want you to make me think that you are dressed like you're going for court. Now, below that, you may have blue jeans on or shorts. You may not have any shoes on. I don't care about that. But the part I can see, I want to make sure that it's very formal. Okay, keep that in mind. I want you to always say Your Honor. I want you to say counsel always. Yes, sir. No, sir. Um, even if the person is much younger than you, I want you to call them sir or counsel. I want you to show the proper amount of respect. You may not respect somebody outside of court in your personal life. That's fine. But in the courtroom, I want you to go to great lengths to show proper respect and to observe proper court protocol. When the judge walks in, I want you to stand up. When the judge leaves, I want you to stand up. Same thing for the jury. Maybe the judge says, oh, we don't do that here. Maybe nobody else stands up. I still want you to do it. If the judge looks at you, I want you to be nice. Good morning, Your Honor. Right? Okay, Mr. Interpreter, would you mind moving closer? Yes, sir. That'd be fine. Yes, ma'am. I'm happy to. Right? I want very respectful, good interpreters because I want your work to shine through and I don't want there to be any concerns about your level of professionalism, the fact that you were a little bit too too informal. Keep in mind, it's much easier to start very formal and to become less formal with time as you become more comfortable in a setting. It's much more difficult when you start off too informal and you have to be corrected, right? We have to tell you, dress better, call the judge sir, right? These types of things. If the judge talks to you, if you're sitting there interpreting and says, Mr. Interpreter, do you know where the counsel is for your hearing? You know, a lot of interpreters would say, no, Your Honor, I don't. No, what I want you to do is stand up. I want you to stand up and to address the court standing, okay? Show that respect. I think these types of things are important. You know, other examples of protocol, we talked about dress code. We talked about courtroom protocol. Um, Being as unobtrusive as possible. It's not the interpreter show. I know, you know, I'm all about interpreting all day, every day. Language access is sort of my life. But what we do is really a small part of the judicial process. And I want you guys to keep that take that into perspective, right? Keep it in that perspective when you go in. I want you to focus 100% on the linguistics of what you have to do. But I want you to also know that that judge is extremely stressed and overwhelmed and dealing with all kinds of stuff. And the last thing he needs is a diva interpreter, okay, causing problems. I want you to go in and do your job, and then I want you to go home. And if you do that, you do good work, I promise you'll be called back. Let your work speak for itself. That's what I mean by not being obtrusive, by being as unobtrusive. That doesn't mean you can't interrupt the court when an impediment comes up. You have to do that. I want you to do that. But I also want you to go in, do your job, do it well, maintain your social distance, so to speak, right? Make sure that you have an appropriate relationship with everybody there. Let your interpretation speak for itself. And I promise you, people will ask for you by name if you do that. If you're the interpreter that after every time we send you out, we get a call or a complaint, or you call us to tell us about something weird that happened, you're the drama interpreter. Don't be the drama interpreter. Do the job correctly, and then go home. And you live to fight another day. I promise you, everybody on this planet is going to want to work with you, and I certainly will. I know my team will. Be that interpreter, all right? Use the first person when interpreting, right? So you're going to say it exactly how they say. And then I went there, and then I did this. You're going to say it that way. You know that. Use the third person to identify statements that you need to make for the record. Your Honor, the interpreter has a question. Your Honor, the interpreter needs to clarify. Your Honor, may the interpreter use the restroom? We do that for the record, okay? If you have to correct the record, there's no problem. You may make a mistake. Your Honor, forgive the interpreter. The interpreter needs to correct the record. The interpreter said white when he should have said blue. That's it. Your Honor, the interpreter needs to make a correction for the record. The interpreter said Monday. The correct interpretation was it should have been Tuesday. You're great. Somebody challenges you. There are people who speak your language in court and they say, that's not what he said. Well, you take a second, you consider it. You think, am I right or wrong? You know what? He's right. He's right. I did mess it up. Your Honor, the interpreter stands corrected. That's all you got to say. Maybe you say, Your Honor, the interpreter stands corrected. The correct interpretation should have been this. That's fine. Or you consider it and you realize that this guy, this attorney, doesn't really speak your language. They don't really know. That's probably the case. They don't know what they're talking about, and you're totally right. And then all you have to say is, Your Honor, the interpreter stands by his interpretation. That's it. If the judge wants to talk more about it, we can come up to the bench and we can do it. What I don't want you to do is screaming in the middle of court, arguing with the attorney in the middle of court, giving dirty looks in the middle of court. It's not personal. That attorney doesn't have anything against you per se. That attorney's doing everything he or she can to help the client. Remember that. And sometimes that means they try to throw the interpreter under the bus. Just stand up for yourself, right? In a professional way. The interpreter stands by his interpretation, Your Honor. The interpreter feels strongly that his interpretation was correct. He stands by interpretation. Okay. All right. We'll go up to the judge if they want to talk more about it. More about it. We can do that right in front of the bench. We can do that, but let it work itself out. Let the judge handle it. It's not personal. Remember that. All right, exercise 9. We're getting close to finishing up here. You are tandem interpreting with another interpreter in a jury trial. Your colleague is on the witness stand and interprets something incorrectly. You hear it. It's a mistake. It's not that you think it's bad and she did it, she thinks it's right. No, it's really wrong. It really is. The error goes unnoticed by everyone but you. What do you do? So how many of you say immediately you go to the judge? Yes or no? Do you go to the judge? Let me see. So you heard the mistake, yes or no? Do you go to the judge? Okay, generally no. I see a yes in there. So here's the answer to this. We may have to go to the judge, but we need to correct it another way first. We need to talk to our partner, okay? So if my partner made a mistake, it may be an innocent mistake. Maybe she doesn't even know. Maybe he doesn't know, right? And so I speak with my partner. Your Honor, may the interpreters have a moment to consult? Yeah, sure, go ahead. Hey, I heard this. I heard that it was a white car. You said it was a red car. What do you think? Right? And maybe they say, oh, you're right. Let me correct it. And they correct it right there. Maybe that we don't even have to interrupt the proceeding because they can just work it back in to the interpretation. Maybe, right? Or maybe they say to you, nope, I heard it was I heard it was red car. It was red car. And you try again. No, it was definitely white car. I wrote it down and I heard it. And I even remember seeing the picture that they put up here. It was white car. No, it was white car. Nope. Nope. It was red car. There's a disagreement. Then you have to go to the judge. Your Honor, may the interpreter's approach, you still do it in a very calm and professional way. You go up, you don't argue in front of the jury. Your Honor, I believe there was an error. My partner and I have talked. We disagree on what the correct interpretation was. I believe it was white car. My partner interpreted red car. Um, we would like, how could we correct this? We need to correct the record or potentially find out if there was a mistake. How would the court like to proceed? Let the judge deal with it. Probably what they'll say, well, since both of you are so sure that you're right, let's just re-ask the question. Counsel, can you re-ask the question? They'll re-ask and we'll go through, right? And you'll both be very careful that next time. If you go to the judge, keep in mind you've made somebody pretty upset, your partner, right? But you gave your partner some opportunity. I've never had this really happen in real life. When there have been mistakes, and there have been lots of mistakes, don't get me wrong. I've made mistakes and my partners have made mistakes, but we work very closely together. Even if there's a disagreement, even if I think it was red and you think it's white, if we are not in agreement, what I would do as the person who made that error, I would say, uh, Your Honor, may the interpreter request that counsel re-ask the question. Right, we'll just ask for it directly. We don't have to go to the judge. Let's just re-ask, right? I want to err on the side of caution. I think strongly that I'm right, but let's ask again. Keep that in mind. That's very, very important, right? Let's see here. Let's keep going. Almost finished. Interpreters shall continually improve their skills and knowledge and advance the profession through such activities as professional training, education, interaction with colleagues and specialists in related fields. Your training never ends. You guys know this. That's why you're here for this free online ethics today, and I applaud you for being here. Keep practicing, keep training. The worst thing that you can tell me as one of our interpreters is, Joshua, I'm not going to do any more continuing education. I've done it all. I don't have time. I'm not interested in learning. I know it all. Either work with me or not. Well, all right. I think I will not, right? Because an interpreter who gets to that point is somebody who has closed his or her mind to the point that they're probably no longer useful in court, to be quite honest. I've met lots of interpreters this way. Don't be that way. No matter how long you've been doing it, no matter if you're the new guy or you've been doing it for 40 years, there's always stuff to learn, to review, new concepts, new things, right? New things to learn. Keep learning. You have to do it. That's why we're so interested in requiring professional development, continuing education every year here in Kentucky. I think it's an integral part of what we do. And I want to encourage you guys to keep learning beyond the 9 hours that we require. Always, always keep working on it. Keep practicing your trade. You know what happens to certified interpreters who don't practice and don't continue to study? They're horrible. They become horrible. You passed a test one time 50 years ago. That means nothing. It means nothing to me right now. What I'm concerned about is what level are you at today? And the only way you keep that level up is to practice and to go to trainings and to keep learning and to keep thinking, right? Keep interacting. It never ends. And that's the beautiful thing about our profession. So, closing thoughts here, guys, in the last minute as we finish up. Who gets hurt when an interpreter's ethics are not observed, when you don't do the things we talked about? Well, the LEP's individual due process rights are violated when that person's not able to participate in the legal process, right? The legal system fails when judges and attorneys can't make informed decisions regarding an LEP defendant's case because they can't communicate. Justice is definitely not served. English speaking defendants don't get the so-called help from unethical interpreters that some of their non-English speaking counterparts get. If you offer more assistance, right, than you should, well, that's unfair to those English speaking participants. They're not getting that. There's no little voice in their ear telling them what things mean. Your colleagues and the interpreter profession as a whole lose credibility. If one person does something unethical, that sort of taints the reputation of the whole profession. Somebody has in their mind that that's how interpreters work based on just your actions. That hurts us all. We, as court interpreters, lose credibility when we become responsible for the outcome of the proceeding, when we take matters into our own hands, right? We try to affect the outcome of the proceedings. Obviously, we lose credibility. That's well beyond our parameters. We know that. Okay, These are things that you should now know how to do. I'm not going to actually do a quiz, but we should be good. Make a correction. You remember that, the Kentucky way. Handle a party that speaks too fast, slowly. Put the smack down on that. Interpret the utterance of obscenities. Come on, you guys, you know you want to do it. It'll be fun. It'll be good, right? And there are books about that. You should get a dictionary. Learn that stuff. It's technical, actually. How do you handle a challenge to your rendition? You know how to do that now. Addressing conflicts of interest. We talked a lot about that. Gifts and gratuities. If it's $1 million, you may accept it, but if not, you can't accept it. You know that. Address errors made by a colleague. I think we talked about it a little bit. Training and resources. I'm going to put a few things on here I want you to look into, a few different organizations that are fantastic for court interpreters as you continue to hone your skills. Last thoughts, guys. All interpreters make mistakes, but good interpreters address them and learn from them. All interpreters have limitations, but good interpreters know them and constantly work to overcome them. All interpreters need a little help sometimes, but good interpreters will always ask for it. And of course, all interpreters learn constantly, but learning really means nothing if you don't apply it. So good interpreters work to apply what they learn. And that's what I want to ask you to do right now after this presentation. We've gone over a lot of things. There was some review information, and there was also some new information. I want you to take into account what we've talked about. I want you to keep in mind the important ethical principles that we covered. I want you to go out in the field and make Kentucky the best language access program in the nation and beyond, because we have the best, most precise, most ethical interpreters that are out there. I believe that. I really do believe that. And I want you guys to go out there and get it done, get the job done that way. That's all I've got, my friends. Appreciate you being here. Thank you so much for joining us. I will send out, it'll probably be next week. I'll send out the recording. I'll send out the slides. I'm going to send out some articles and stuff, just some ethical things. If you are on here and I can see on our tracking device that you have been logged in the whole time, you're going to get your credit. You don't need to follow up with me anymore. Okay. I'll give you credit as long as you've been logged in. If you are watching this after the fact, I want you to follow up with me with the continuing education form. Let me know that you're done, that you finished it, and just confirm that you participated in the whole thing. I'll give you credit. And with this, you should be able to meet your continuing education requirements for ethics. All right. Any questions, guys? I'm going to hang out a couple of minutes. You're free to sign off. I appreciate you being here. If you have any questions, hang out and let's chat on the chat box. Thank you, my friends.
Thank you, Joshua.
Thank you.
Thanks so much. Really enjoyed it.
Thank you. My pleasure, my friend.
Thank you, Joshua. It was awesome.
Mahalo, Josh.
My friends.
Finally light out here in Hawaii. Thanks. Bye-bye.
Nice. Thanks for joining.
Hey Joshua, how you doing?
Mohammed, is that you?
Yes, sir. How you doing?
I'm well, my friend. Good to hear from you.
Thanks a lot.
Do we have the training for the next Friday for first of the month?
Yeah, we'll still have that call next Friday, just our regular catch up. Yeah, I'll send out a reminder next week.
Okay.
Happy Halloween, everybody. Stay
Happy
safe.
Halloween. Indeed.
Bye-bye.
Joshua, Miami's asking about you.
Man, I love Miami. Who is this?
This is Chris.
Chris Hobel, my good buddy. I couldn't recognize you for a second. Yeah, man, I miss my buddies in Miami, man. I will always have in my heart the people we worked with there. Hard to leave. Hardly good to come home. Hard to leave. Yeah, but I appreciate that. Thanks for saying that.
Thank you, Your Majesty.
Your Majesty, King Marcel, Your Highness.
Thank you.
Yeah, my friend. Good to hear from you guys. Let's see. I'm going to look at the chat box. Let me see here if I haven't missed any questions. I think we're good here. Thank you. Thank you, Elisa, so much for saying that. I appreciate that. And Sixta, I'm glad that you're on here, my friend. I'm glad you joined us. Let's see. Hold on, guys. I'm going to mute. I'm getting some feedback there. I just muted a couple of people. Let's see here. So Mojkin says, sometimes the person whom I'm interpreting for knows English well and wants to do the talking. The reason they ask for an interpreter is to make sure they understand everything you do in the case. Yeah, and that's fine, Mojkin. We sort of call this standby mode. And it's fine. If you get there and it's determined that the person actually speaks English pretty well, maybe they want to clarify occasionally, or maybe they want to hear it in their English, in their language, but then respond in English. That's okay. There's no problem with that. It doesn't have to be all or another. Just make sure that you disclose that to the judge at the beginning. Your Honor, before we get started, forgive the interpreter. The interpreter would like to mention that she's been informed by the defendant that the defendant speaks English She just wants the interpreter here for standby mode. Could the court inquire about this? Let the judge make sure that's true. Just tell them up front, but that's fine. You can be on standby mode for sure. Yep. Thank you, Elisa. Thank you, Minu, as well. I appreciate you being here, my friend. All right, guys. I think that's all I got, man. Have a great weekend, great holiday weekend, Halloween weekend. I'm definitely going to be out with my 4 little munchkins. It's going to be fun. So hope you guys have a good weekend. Don't eat too much candy. Be safe. Keep your masks on, which is actually the best day in the world to keep the mask on. So it's going to be fun. All right. Take care of yourselves, guys. We'll talk soon. Be in touch.